live on our website. And now I have an early warning for you. We have more than 30 people signed up on the speakers list for the discussion after agenda items 6 and 7. As you have all previously been informed, the list of those wishing to take the floor in the general debate was formally closed an hour ago. Due to this very high interest and our limited time available, all debate participants are requested to limit their interventions to 2 minutes. I ask everyone who intervenes to please pay attention to the timer, which will be visible on the screens. This will help ensure that, that we can all engage in the discussion. Thank you. Colleagues, as you have seen, the agenda for our meeting has been circulated. I understand that many of us may wish to address recent developments. I think this can be done within the frame of our planned agenda, and I hope that we can agree on the agenda that has been circulated as the basis for our meeting. I see no objections, so the agenda is adopted. Thank you. With that, I'll move to the agenda item 2. Friends, we have a very busy schedule today, so I will not take very much time. However, I would like to inform you of some of the work that I and colleagues have been doing on your behalf in the past half year, which in the past year we have witnessed yet another brutal aggression of Russian Federation against OSCE participating state, which costs thousands of lives and the destruction of cities and villages in Ukraine. This is the second aggression of the Russian Federation in the 21st century against an OSCE participating state, and now 2 countries, Georgia and Ukraine, or parts of these states, are occupied by Russian Federation, and some parts are annexed by Russian Federation. Of course, we all condemn this violation of fundamental international law, and we should stand united in this assembly against aggression, occupation, and annexation of sovereign territories of another state. Together with my colleagues Farah Karimi and Johan Buza, I have continued to bring attention to human rights problems as they have occurred. On many occasions, our statements and communications have been done jointly. I think this is a strong sign on behalf of the committee, and I thank them both for their cooperation. Our work has taken several parallel approaches. We have spoken on thematic issues such as challenges to democracy. We have spoken out on specific localized issues such as the persecution of the media and NGO treatment in Russia. And we have had a number of in-person interactions to promote our OSCE PA work. All of us have maintained an open dialogue with human rights defenders and analysts, as well as with state authorities in various countries. For example, I was able to attend the OSCE's Human Dimension Conference in Warsaw late last year. This enables us to engage in constructive dialogue that can hopefully result in positive changes. We have only spoken out publicly when we thought it was particularly urgent and important to do so. In the face of persistent and grievous problems, I think it is our responsibility. I was also pleased to host Farah and Johan in Tbilisi a few weeks ago. This visit gave us the opportunity to meet and plan our work, but I hope that it also enabled Johan and Farah to familiarize themselves with some of the challenges in Georgia, particularly due to Russian occupation. Such visits serve as an excellent opportunity to continue our committee's practice of meeting with national human rights bodies, so we can benefit from their experience and maintain awareness of priorities. I do not want to take more of our limited time, but you can rest assured that we will continue to work actively on behalf of the committee on priority human rights topics. We will now move to agenda item 3. Our rapporteur, Johan Buza, re-elected at our meeting in July, will now give us initial overview of his intentions concerning his report for the upcoming annual session in July. I have already had the opportunity to discuss some matters with Johan, and I very much look forward to seeing the report in the coming months. You have the floor, Johan, and I ask you to please keep your comments within 5 to 7 minutes if possible.
Thank you so much, Nicholas. And I also would like to start by thanking Nicholas Samarkandche and Farah Karimi for a very good cooperation within our third committee. I also would like to thank the Secretariat for the cooperation we've had together during these months. So, dear colleagues and dear participants, the world faces major challenges, both new and old. Pandemics, military conflicts, social economic inequalities, a refugee crisis, racism and harassment against women, against journalists, and against human rights defenders. They are just a few of the seriously concerning issues facing us. Amid widespread disrespect for human rights and fundamental freedoms, the values and rights enshrined in the Helsinki Final Act serve to remind us that these principles must continue to be the foundation of all societies across the OSCE region. Of course, it is difficult to have a dispassionate conversation about principles today on the eve of anniversary of Russia's brutal, unprovoked, and justified war of aggression against Ukraine. The most fundamental right, the right to life, has been taken away from countless innocent victims because of Russia's hostility. The war has caused immeasurable suffering in terms of death, abuse, displacement, and other traumas. We must not forget the human impact of the war. In the face of such abuse, it is more important than ever that we come together to protect our shared human rights values. We must continue to raise issues both internationally and in our own countries and hold our governments accountable. In my report and in my resolution, I plan to focus on 4 broad groups of challenges, and I intend to propose implementable recommendations to the current challenges we face in our region. First, we must continue our work to ease the suffering caused by war and support those brave individuals standing against these abuses. Russia's war is a grave breach of the international human rights law, and there is mounting evidence of war crimes affecting both civilians and combatants. It has also had a particularly devastating effect on vulnerable groups. Russia's attempted annexation of the Ukrainian regions of Donetsk, Luhansk, Kherson, and Zaporizhia is a grave escalation of the situation, but this is best addressed by colleagues in our Political Affairs Committee. The reality of an ongoing war limits our ability to step in and protect people's human rights. And that being said, I intend to listen carefully to our discussion today about accountability during times of conflict, and I expect to present recommendations emanating from this debate. Accountability will be critically important. One aspect that we must continue to fight for is that prisoners of war must always be treated humanely from the moment they are captured. We all know that this is a clear obligation under international humanitarian law. Furthermore, we should also express concern at the crackdown on anti-war protesters, independent media, and political dissent in the Russian Federation and Belarus, Russia's main ally in the war. While Russia has shown shocking disregard for human rights, we must all continue to use whatever leverage is possible to get the Russian authorities to apply their domestic and international commitments. Let me also stress that Russia's war against Ukraine is not the only conflict-affected area of our region. I was recently in Georgia, like Nicholas said, and I heard about the challenges, even decades on, of the conflicts in that country. The situation also along the Armenia-Azerbaijan border continues to have a real human impact and requires continued effort to find a lasting and peaceful solution. Second, the outbreak of the COVID-19 pandemic and the war in Ukraine have further amplified economic inequalities and had major social economic consequences across the world. I expect that the cost of living crisis is a major focus for most of our parliaments. We must take this seriously also because political discontent related to democratic processes is often rooted in socioeconomic disparities. We must do all we can to ensure that the economic crisis many of our populations are facing does not become a political or democratic crisis. The recently uncovered plot to overturn democracy in Germany is a reminder that democracy and democratic principles cannot be taken for granted. As parliamentarians, we must pay additional attention to our support for the rule of law and work together to find suitable solutions to prevent the further damage to democratic institutions and election processes in our region. Sorry for that. Third, we must pay special attention to supporting vulnerable groups in society, most notably minorities' rights and their full inclusion in economic, political, and social life requires dedicated attention. This includes LGBTI people, religious, racial, and ethnic minorities, and indigenous peoples who we regularly see face serious threats and discrimination. For example, the new legislative amendments against LGBTI rights in Russia further restrict freedom of expression and is once again undermining Russia's obligations. The declining respect for minorities' rights, especially for LGBTI people, and virtual criminalization of certain identities is a serious violation of OSCE principles. We must strongly condemn such acts and do all we can to encourage greater tolerance and inclusion within our societies. The intensifying violence against women in journalism and politics is a trend that cannot be allowed to continue. I hope that we can work to develop solutions to support freedom of expression and assembly for all people. The war in Ukraine has also resulted in the forced migration of a third of its population. Women, children, older people, and people with disabilities, especially, have been placed in extremely vulnerable situations. We must continue to offer protection to all refugees fleeing the war in Ukraine and to offer them the conditions to continue their lives in a dignified way until they can return to their country if they so wish. More serious attention must also be paid to the issue of human trafficking and other forms of exploitation, which continue to pose a threat to people on the move and to combating technology-facilitated trafficking in particular. And finally, in the context of rapidly expanding global emergencies, I want to underline the intensified impact of digitalization on people's rights. Online harassment and abuse, especially of women and human rights defenders, is a global problem that crosses borders. Harassment and abuse did not start with the digital era, but technology has dramatically amplified the damage. If we consider the internet to have been weaponized to these ends, we must start to consider how to disarm this sphere and to make this a safe space for all. We should also pay close attention to the use of artificial intelligence systems, which can also be misused and pose the potential for serious abuses of human rights. In a similar manner, disinformation and propaganda, together with cyber attacks, have been weaponized, particularly in the war of Ukraine. These are causing real damage with devastating effects on all of our societies. We must continue to search for effective ways to counteract disinformation and rebuild public trust in reliable information from verifiable resources. As parliamentarians, we must support the effective implementation of human rights for everyone. Our collective responsibility is to protect their fundamental freedoms, be it online or in the streets. Dear colleagues, last year was challenging for all of us. As parliamentarians, it is our duty to find solutions to the many difficult issues we face in our region today. I remain convinced that a coordinated response can strengthen the commitment in the human rights dimension of the OSCE region and thereby contribute to our collective security. I hope to work closely with you to find real solutions, and I would therefore welcome any comments, and I also thank you for your attention. Thank you.
Thank you, Johan. We will take comments to your report after agenda item 6. I'm now an old friend of the OSCPA and former chair of this committee. However, as you can see, he's unfortunately not here with us today, but he is joining remotely. A former member of parliament in Italy and longtime activist in a number of human rights areas, I'm pleased to welcome you back to the OSCE PA as the director of the OSCE's human rights body. We have long enjoyed close cooperation with your office, and I'm sure that this will only continue to improve under your leadership. Mr. Mekachi, you have the floor, and I ask you to please keep your comments to some 5 to 7 minutes.
Thank you. Thank you, Mr. Chairman, Sar Kamadze, Rapporteur Boozer, Excellencies, members of the Parliamentary Assembly, and all friends there in Vienna. Allow me, first of all, to start by expressing my gratitude to President Margareta Sederfer and Secretary General Montella for this opportunity to contribute to your winter meeting, although I have to do it regrettably remotely, but thank you for the opportunity. And I wish to do so even more as it becomes a regular invitation that we receive, which underlines not only the close partnership that ODIHR and the Parliamentary Assembly have achieved, but also our common desire to reinforce it at a time when our human dimension, the respect for democratic principles and human rights must remain at the core of our OSCE efforts. As we mark tomorrow 1 year since the start of the military attack by the Russian Federation in Ukraine and the immense humanitarian crisis it is still unraveling, we must all be determined in calling for these human rights violations to end and remain resolute in offering our contribution towards accountability. I feel we owe this today, as any other day, to the millions of civilians affected by this conflict, and in particular to the men, women, and children whose fundamental rights have been taken away in the most tragic of circumstances. While reason remains to believe that the number of civilians killed and injured during the conflict could be much higher, as of February 13th, the total number of civilian casualties recorded in Ukraine is almost at 19,000, including over 7,500 civilian deaths, according to the United Nations. As I've mentioned to you in more details in November when I participated in your autumn session in Warsaw, ODIHR has been swift in starting to monitor and document violations of international human rights and humanitarian law in Ukraine since the early days of the conflict. Through the deployment of monitors and interviews on the ground with more than 130 survivors and witnesses of violations both in Ukraine and outside the country, we have been collecting testimonies of alleged violations which were published in 2 reports in July and December 2022 to ultimately contribute to the goal of accountability. Both reports found credible evidence of a general disregard by the Russian Federation for the basic principles set out by international humanitarian law in the conduct of hostilities. And there have been also indications to a much more limited extent that also the Ukrainian armed forces failed to comply with specific rules under international law on the conduct of hostilities. As this conflict sadly goes on, ODIHR is continuing this crucial and impartial, and I want to stress here the word impartial, monitoring work in 2023, in close coordination with relevant authorities and other organizations which are conducting similar monitoring in the country. We are grateful to the courage of the witnesses and survivors who have been provided us with their testimony. At the same time, ODIHR's assistance to Ukraine is enriched by several other initiatives offering a unique comprehensive approach to the current situation. These include, for example, the assistance to the Ukrainian parliament to increase its democratic standards, support to judicial bodies with targeted expertise on international human rights law, building of capacity to combat human trafficking in countries which are neighboring Ukraine, the training of human rights defenders which are working in and on Ukraine, and monitoring of human rights violations and discrimination affecting the Roma people who have fled the conflict. As we progress with this work and new initiatives are being developed, I trust in the partnership and support coming from the Parliamentary Assembly and this committee in particular. Ladies and gentlemen, perhaps the most profound lessons we can all take from the ongoing war in Ukraine, in my eyes, remains the firm belief that when fundamental human rights begin to be limited or violated, democratic standards and institutions undermined, and civil society voices are restricted, security is fragile, and our society suffers. ODIHR has been ringing this bell for many, many years. but unfortunately, many turned their heads in another direction. This is why preserving and indeed further strengthening the human dimension of the OSCE is, in my view, the most important contribution we can all make to peace and security in our region. In this respect, allow me to renew my invitation for closer cooperation between ODIHR and the OSCE as one of the genuine assets that the OSCE can put forward in overcoming present challenges and to reinforce democracy and human rights in our countries. Here, our joint work, for example, on observing elections across the OSCE region continues to be essential, also for security and stability. With important elections coming up this year in Kazakhstan, Montenegro, Turkmenistan, Albania, Turkey, Poland, Bulgaria, just to name a few, we look forward to our cooperation whenever it is possible. At the same time, ODIHR values the support given by the Parliamentary Assembly in strengthening our assistance to OSCE participating states on electoral reforms and follow up to our recommendations. We continue to count on your support also as members of your respective national parliament in promoting efforts to align national legislation with OSCE commitments. In similar way, allow me also to highlight here the assistance that our office continues to offer to parliaments across the OSCE region in reinforcing their legislation-making processes, both through ad hoc legal opinions on specific legislation, as well as by assessing their whole legislative processes that we have done, for example, in 2022, with 24 legal analyses, which have covered 14 OSCE countries, and we have conducted 3 comprehensive assessments of legislative processes in Bosnia and Herzegovina, Uzbekistan, and Armenia. One concrete success of ODIHR legislative assistance this year is the recent amendments to Moldova's hate crime legislation, which was adopted in June 2022, which reflect almost all the recommendations we have made on an earlier legal opinions. The work of the PA and you, as the third committee, has proved and continues to be an important asset in this regard, raising the attention on selected situations of concern and promoting at the national level the opportunity to request legal opinion for ODIHR. These are naturally only 2 examples of numerous areas in which ODIHR and the OSCE work together and can further advance our cooperation with parliamentary integrity, violence against women, including against women in politics, the rule of law, in addressing intolerance and discrimination being part of this wider list. Our partnership remains crucial as we move forward upholding OSCE commitments while defending our common international legal order and its robust set of protections for human rights and democratic principles. As always, I look forward to continue working closely with the OSCE and its third committee, in particular this year, as we advocate for security in our region grounded on human rights, democratic elections, tolerance, and equality. I thank you for your attention and support, and I look forward also to hearing your discussion and reflections, and I will stay online for the following debate. Thank you.
Thank you, Matteo. Now we move to agenda item 5. Unfortunately, Teresa Ribeiro, the OSCE representative on freedom of the media, is also not able to join us in person. It seems she is traveling at exactly this moment. She has therefore sent a pre-recorded video message. While I regret that this stops us from having any direct interaction with her and asking any questions, given the importance of the issues that her office deals with, I thought it is useful to hear what she has to say. Teresa has been a vocal advocate in favor of free media on behalf of our organization. As parliamentarians need good and accurate information to take informed decisions, the importance of this for our work cannot be underestimated. Before asking for the video to be shown, however, I would like to take this opportunity to note that exactly 20 years ago, in this room, during the 2003 winter meeting, our assembly awarded the OSCE Prize for Journalism and Democracy to Anna Politkovskaya, a Russian journalist with the independent Russian newspaper Novaya Gazeta. The award was in recognition of her extensive and balanced reporting in Chechnya, drawing attention to grave human rights abuses in the region. Her brutal assassination 3 years later and the recent steps by Russian authorities to shut down Novaya Gazeta unfortunately speak volumes about how the free press is treated in Russia. As you can hear, the OSCPA has been a long advocate of media freedom, and I'm pleased that we continue with this tradition today. I would now ask the technicians to please play the video from Ms. Ribeiro.
Excellencies, Chairman and members of the General Committee on Democracy, Human Rights and Humanitarian Questions. It has been exactly 1 year since our world changed. 1 year ago, I addressed this committee just the day after the Russian Federation's full-scale invasion of Ukraine. I remember back then, I was struggling to assess the consequences of the headline that was all over the news and what this would mean for our common security, our region, and our organization. Nobody did. And today, 1 year into this deadly, devastating, and horrifying war, we witnessed in Ukraine shattered cities, thousands of deaths, millions without a home. We feel the consequences throughout our region and in this very organization, our common values and commitments, the foundation which our organization is based upon, cooperation and trust, have fallen victim to this devastating war. It is also devastating for the media in Ukraine. Hundreds of media outlets were forced to shut down as a result of the war. So, when rebuilding the destroyed infrastructure in Ukraine, we will also have to think about rebuilding and supporting the Ukrainian media sector, which will require a comprehensive international response. The media workers that stayed or came to Ukraine to report on the war ran great risks. The safety of journalists reporting from these conflict zones is of major concern. At least 8 journalists and media workers, national and international, have been killed while on duty. Many more have been wounded or forced to relocate. It is stating the obvious, but let me say it once again, clear and sound. No journalist should be targeted for doing their job, not in situations of armed conflict and not in peaceful times. The consequences of this war and its run-up are also very tangible in the Russian Federation, where journalists risk imprisonment and high fines if they even mention the word war when reporting on the devastation caused by the Russian Federation in Ukraine. Hundreds of journalists have been labeled as foreign agents, and several independent outlets as undesired organizations. We are witnessing the most severe clampdown on independent journalism in our region since the establishment of the RFOM institution 25 years ago. Almost all highly respected independent news outlets were forced to leave the country and continue their operation from abroad. This systematic clampdown on media freedom is not confined to the Russian Federation alone. Regretfully, the same holds true for the Belarusian independent media community. Dozens of journalists in Belarus face criminal prosecution and imprisonment on trumped-up charges, while hundreds have left the country to be able to do their work without repression or having to fear for violent attacks. All of these media workers deserve our solidarity and support. And this goes for all journalists in our region. The regressing media freedom situation is unfortunately a reality in many parts of the OSCE. With the backsliding of democracy comes the repression of independent voices and vice versa. I cannot stress enough the essential role of free, independent, and impartial media for peaceful, democratic, and just societies. Parliaments have a central role to play when it comes to ensuring an enabling environment for journalists and preserving media freedom. Now is the time to act. for all of us if you want to turn the tide on this downward spiral. When the mandate of the OSCE representative on freedom of the media was established 25 years ago, a mandate that I'm proud to hold for over 2 years now, the participating states understood very well the important role that free media play for peace and security in our region. But is it still the case today? In today's climate of crisis, turbulence and uncertainty, more than ever we need political will and a strong commitment to media freedom as a key pillar for security. The sad reality, however, is oftentimes quite the opposite. Political will to protect journalists is being traded for hostility against the media, tearing down its crucial role in democracy, peace and security. Antagonism to freedom of speech has become commonplace in too many parts of the OSCE region, with a range of strategies from censorship, media capture and legal repression to the overflooding of information spaces with disinformation, and in some cases even the weaponization of speech itself, including through state-led influence operations as a tool to engineer a war. In times like this, it is not only expedient but necessary to discuss and strategize around the large number of emerging challenges, challenges that are growing in scale and complexity. It is against this backdrop that I published a report entitled "Can There Be Security Without Media Freedom?" A report that is based on consultations with 9 eminent experts and that serves us all with a critical assessment of the role of the media for peace and security. You can find it on the RFOM website, and I encourage you all to read it. The topic of today's sessions, accountability for human rights abuses in times of conflict, is a very crucial one, because there can be no lasting peace if there is no justice, an important lesson that we have learned throughout history. Let me remind you of the critical role that journalists play in this context. They not only report on the developments and events in the conflict zones, putting themselves in enormous danger, they also gather and collect valuable information and data on human rights abuses that are essential for future accountability mechanisms, be it on a national or international level. Journalists are at the forefront when it comes to being witness of such horrible crimes, and their reporting and documentation can support evidence for trials and convictions. Fortunately, there are still journalists willing to fulfill this double role in times of conflict, often at high costs. This is why their safety is key. I will continue to do everything I can in order to promote journalist safety, both in times of peace and conflict. Thank you.
Dear colleagues, now we move to agenda item 6, and I'm pleased to welcome Ambassador Callan to our committee. Ambassador Callan is the chairperson of the Human Dimension Committee of the OSCE Permanent Council and permanent representative of Ireland to the OSCE. Thank you for coming in person. I look forward to what plans you have for the Permanent Council's Human Dimension Committee. The committee you chair is effectively our committee's counterpart on the governmental side of the OSCE, so it is very important for us to hear your input. We would appreciate if you could please keep your remarks to 7 minutes. You have the floor, Ambassador.
Mr. Chair, Rapporteur Boozer, distinguished parliamentarians, thank you for the invitation to speak today and for the opportunity to provide you with an outline of the plans for the work of the Human Dimension Committee in 2023. I would like to thank North Macedonia, the chairperson in office, for asking Ireland to chair the Human Dimension Committee this year. Let me also thank Ambassador Anne Kirsty Carlson, permanent representative of Norway to the OSCE, and her team for the excellent work they have done on the Human Dimension Committee over the past 2 years, and also the Polish chair in 2022 for their leadership at a challenging time for the organization. Tomorrow is the anniversary of Russia's unprovoked war against Ukraine, which has had appalling, brutal, and tragic consequences for the country and its people. All of Ukrainian society has been affected, including women, children, the elderly, and people with disabilities. In view of the war's devastating impact on human rights, Ukraine must remain at the forefront of our work in all of our meetings in 2023. The priorities of the North Macedonia chairperson in office in the Human Dimension are guiding the work of the committee. These priorities include addressing discrimination and intolerance, combating trafficking in human beings, freedom of the media, social inclusion and integration in democracies, and the eradication of violence against women. Ireland welcomes the commitment of the North Macedonian chairperson in office to actively engage with civil society and to place a high priority on youth over the course of this year. The January meeting of the Human Dimension Committee focused on consultations with the committee to seek input from delegations to ensure a balanced and comprehensive programme for the year. Earlier this week, on the 21st of February, the committee discussed the right to education in war, conflict, and humanitarian crisis. Over the last year, participating states have responded to the largest humanitarian and refugee crisis in the history of the organization due to Russia's war of aggression against Ukraine. Dr. Andriy Vitrenko, First Deputy Minister of Education and Science of Ukraine, joined the meeting and to outline and set out the challenges that the education sector in Ukraine has had to grapple with this year. Having heard his perspectives and the interventions of other speakers, including humanitarian agencies and civil society, participating states discussed the various approaches to vindicating the right to education in war, conflict, and humanitarian crises, and with a major focus on the Ukrainian refugee crisis situation. In the coming months, it is our intention that the Human Dimension Committee programme will focus on issues including combating sexual violence as a weapon of war, supporting tolerance and non-discrimination, including challenges for Roma and Sinti in the OSCE area, freedom of the media, democratic institutions, freedom of peaceful assembly, combating trafficking in human beings, addressing the shrinking space for civil society and the safety of human rights defenders, and the OSCE's contribution to upholding international humanitarian and human rights law. We intend to integrate the broad human rights framework and gender equality into our discussions. We will also involve a wide range of stakeholders in the work, including OSCE field missions, the OSCE Secretariat, ODIHR, the Representative on Freedom of the Media, the High Commissioner on National Minorities, the OSCE Special Representative and Coordinator for Combating Trafficking in Human Beings, international organisations, NGOs and civil society. Mr. Chair, the events of last year have highlighted the importance of the OSCE's comprehensive concept of security. We can be in no doubt that the protection of human rights and fundamental freedoms is crucial for sustainable peace and security. All OSCE participating states have committed to implement the OSCE acquis, of which human dimension commitments are a core component. It is incumbent on all of us to implement our commitments and to work to develop our understanding and enhance our tools for so doing. We look forward, in close collaboration with the chairpersonship of North Macedonia, to cooperating with participating states in the human dimension and the OSCE Parliamentary Assembly delegation to the OSCE to that end. Thank you.
Thank you, Ambassador. We look forward to continued close cooperation. With that, I will now open the floor for questions or interventions related to the topics addressed by our guest speakers. The first speaker on my list is Mr. Tural Ganjaliev from Azerbaijan, followed by Ms. Ingrida Sirsene from Latvia.
Thank you very much, dear chairperson, dear colleagues. We emphasize that addressing human rights violations, in particular those related to atrocious crimes, is of significant importance. The most serious international crimes committed in armed conflicts have not received proper attention. As a consequence, the lack of accountability and impunity enjoyed by the perpetrators not only constitute a defiance of international law and human rights, but also represent a direct obstacle to lasting peace and genuine reconciliation in post-conflict settings. These issues are also relevant to our region. We once again would like to draw your attention to the fact that in the course of its aggression against Azerbaijan, Armenia violated international humanitarian and human rights law by committing countless war crimes against Azerbaijanis, both military servicemen and civilians. Summary executions, torture, inhuman or degrading treatment of protected persons, mistreatment of POWs and civilian detainees, hostage taking, mutilation of bodies of dead servicemen. But nevertheless, Azerbaijan has now fully committed to eliminate the consequences of the past conflict. The normalization of Armenia-Azerbaijan relations with the ultimate goal of signing a peace treaty is being pursued. On this track, direct bilateral negotiations on different dimensions of interstate relations is the best way forward. And of particular concern is that the Azerbaijani sovereign territory of Lachen Road is being misused by Armenia, not only for unlawful military activities, but also for trafficking of natural resources from the territories of Azerbaijan to Armenia. We would like to reiterate today again that Azerbaijan has not put any restriction on the traffic along the Lachen Road, nor did the protesters declare any intention to block the traffic. The reports, news, and video footage disseminated through social media testify to the unhindered passage of the various kinds of vehicles along the road, including civilian and emergency vehicles and those of the International Committee of the Red Cross. Just for your information, dear colleagues, Russian peacekeepers supplied 35 tons of humanitarian aid to Armenians in Karabakh region of Azerbaijan so far. So the shipment was carried out through the Lachen Road. This begs a question. If the road is closed, as Armenians claim, how come that the passage of more than 2,500 vehicles via Lachen Road were carried out? So what has changed on the ground is that for more than 2 months, the Lachen Road has stopped to be used for unauthorized purposes. Armenia has not been able to use the road for military purposes, including smuggling of deadly landmines, arms, and ammunition. Perhaps this is the reason which draws the anger of the Armenian delegation, because probably Armenia has been deprived of continuing its illegal activities that increased its concern so much. We must send direct and clear message to Armenian delegation to stop using the road for military purposes and smuggling natural resources of Azerbaijan. This is the only way forward. Thank you.
Thank you, Mr. Ganjaliev. I will ask again colleagues to pay attention to the clock. Next speaker is Ms. Ingrida Sirsene from Latvia, followed by Mr. Sergei Rachkov from Belarus.
Dear Chairperson and dear colleagues, today here in Vienna, we are allowing aggressor to be among us while we make decisions about security matters. In the meantime, Russia is destroying lives of Ukraine citizens. It's unacceptable to let aggressor to participate. Democracy don't apply to the ones who don't cherish it. Latvia highly values rules-based international order. Impunity is unacceptable. Accountability must be ensured, including for Russia's crimes of aggression against Ukraine. Austria opening the doors to Russia have resulted in Ukraine not participating in this plenary session, country that needs our support the most. Exactly 1 year after Russia declared war on Ukraine, Vienna have welcomed them with open arms here today. I am totally against this kind of kindness for the aggressor who openly don't respect laws of the Charter of Fundamental Rights of the European Union. It is based on the principles of democracy and the rule of law. Austria is a part of European Union where we live by this charter, and in the first chapter, first point of Article 2 says, everyone has the right to life. But right now, Russia believes that Ukrainians don't have the right to life. Yet they are here today in European Union, where we cherish fundamental human rights. I would also like to note out the article number 4 of the charter that prohibits torture and inhuman or degrading treatment or punishment. The completely opposite of what Russia is doing in Ukraine. European Union values don't align with Russia's. In European Union, we value fundamental rights. Thank you.
Thank you, Ms. Sirsana. Now the next speaker is Mr. Sergei Rachkov from Belarus, followed by Val Ritchie, the OSCE specialist on countering trafficking in human beings.
Так, благодарю вас, господин председатель. Права человека – это очевидная ценность. Сегодня очевидно, что права человека становятся также и очень важным фактором экономического развития в 21 веке. Международные институты, которые должны заниматься развитием и защитой прав человека, к сожалению, оказались в очень серьезном кризисе. Кстати, тем, кто уходит из зала, не удастся скрыться от этой сложной правды. Все равно она вас настигнет. Правозащитная тематика сегодня используется в качестве социального оружия, которое дестабилизирует общество. Эти технологии используются не во благо, а во вред для устранения, по сути дела, экономических конкурентов. Иначе как можно объяснить, что массовые демонстрации во Франции, Германии, Нидерландах остаются незамеченными, участники движения желтых жилетов регулярно избиваются, масштабные фальсификации в ходе американских президентских выборов даже не упоминаются, отсутствие свободы СМИ и их тотальная зависимость от финансовых спонсоров маскируется. Все эти процессы достигли уже такой степени, что авторитетные западные исследователи говорят о феномене постдемократии практически во всех странах коллективного Запада. К сожалению, практика показывает, что ни одному институту, финансируемому западными корпорациями и финансовыми группами, сегодня нельзя доверять. Выступая за защиту прав человека, они в реальности нарушают правозащитные механизмы и дискредитируют саму идею защиты прав человека, весьма важную и значимую. Эта ситуация требует изменений, и это не менее важно, чем вопросы безопасности. Благодарю за внимание.
The final speaker on my list is Val Ritchie, the OSCE specialist on countering trafficking in human beings. The floor is yours.
Thank you, Mr. Chair. Over the past year, the displacement of over 13 million Ukrainians internally and abroad, combined with a dire humanitarian and economic situation, has significantly increased their vulnerability to human trafficking across the OSCE region. This situation is directly attributable to the invasion of Ukraine. From the earliest days, the OSCE has put a spotlight on the risks of a human trafficking crisis as criminal groups seek to exploit heightened vulnerabilities of women and children fleeing the war. With demand spiking 200 to 600% for sexual access to Ukrainian women and girls, exploiters are strongly incentivized to recruit victims. Meanwhile, deteriorating financial circumstances of Ukrainians have heightened their vulnerability. Against these risks, recruitment efforts infect all corners of the internet and the first cases of human trafficking involving Ukrainian refugees have already appeared in Europe. In general, many states have promptly responded to the situation by investing in key prevention and protection measures, notably through the activation of the Temporary Protection Directive in the European Union or comparable national arrangements in other parts of the region. The OSCE has also provided strategic advice and tailored technical assistance to enhance the anti-trafficking response in several countries hosting Ukrainian refugees, and we launched an important awareness campaign to help keep people safe. Yet despite this action, at the political and operational levels, the risks remain high. Notably, the 2014 crisis in and around Ukraine led to a four-fold increase in the number of Ukrainian human trafficking victims in Western Europe within just 2 years. This lesson should inspire states today to increase their protection and prevention efforts and to avoid exploitation at a much bigger scale. With this in mind, I call on all OSCE participating states to maintain and scale up their national efforts to reduce the vulnerability of all people fleeing the conflict and renew their steadfast commitment at the highest level towards a future that is free from exploitation. Thank you, Mr. Chair.
Thank you. With that, agenda item 6 is closed and we move to agenda item 7. To a special debate on accountability for human rights abuses during times of conflict, which I agreed in consultation with Farah and Johan. We have limited time, so I'll pass the floor to our guest speakers in just a moment, but I want to underline why I wanted this to be on our agenda today. Colleagues, last year's full-scale invasion of Ukraine by Russia has again brought war to the heart of Europe. It has required many of us personally, but also our organization, to once again consider some of the terrible truths associated with the war. Our assembly has already clearly stated that in its war on Ukraine, Russia has broken all 10 of its Helsinki Decalogue commitments. There is unfortunately nothing that we can do to bring back the lives of the many innocent women, men, and children that have been killed because of Russia's aggression. But I hope that we can honor their lives by engaging in a serious discussion on accountability. While Russia's unprovoked war on Ukraine clearly means that this conflict will shape our thinking, I hope that we can engage in a principled discussion that is applicable also outside of this war. As policymakers, I think it's our responsibility to take a broad perspective when addressing such issues. With that, I will move to introduce our first speaker. Our first speaker is Judge Marc Perrin de Prichambault from the International Criminal Court. The International Criminal Court is perhaps the international community's foremost effort for accountability for grave crimes. I'm therefore very pleased to have this important voice reflected in our conversation today. And I'm particularly honored to welcome back to this building Judge Perrin de Prichambault, who previously served as Secretary General of the OSCE and therefore knows our work very well. Thank you for joining us, Judge. We look forward to hearing your contribution, which I think will shape our subsequent conversation.
Merci, Monsieur le Président. Monsieur le Président, Mesdames et Messieurs les parlementaires, je voudrais, Monsieur le Président, vous remercier de votre invitation de la part de Monsieur le juge Piotr Hofmanski, président de la Cour pénale internationale, qui m'a demandé de le représenter aujourd'hui. La poursuite de la responsabilité pénale des individus qui commettent des infractions aux droits de l'homme relève de deux branches du droit international public, le droit international humanitaire et le droit des droits de l'homme. Je n'aurai malheureusement pas le temps de vous en présenter aujourd'hui le contenu. Ce que je voudrais dire, c'est que ces deux branches du droit international ont été reflétés et cités dans de nombreux textes qui ont été adoptés par les États parties à l'OSCE, en tout particulièrement le Code de conduite des forces armées, adopté en 1994, texte politiquement contraignant qui prévoit que les forces armées sont commandées et entraînées conformément aux dispositions du droit international et aux obligations concernant l'utilisation des forces armées en cas de conflit armé. Les différentes branches du droit sont donc liées entre elles, le droit humanitaire étant considéré comme une loi spéciale par rapport au droit des droits de l'homme. Le droit international humanitaire et le droit des droits de l'homme convergent dans le droit international pénal, qui précise la nature des crimes susceptibles d'être commis en période de conflit armé, c'est-à-dire les crimes de guerre, la violation systématique ou générale des droits de l'homme en application d'une politique, les crimes contre l'humanité, le crime de génocide, et qui judiciarise leur violation. Au centre de ce droit est la responsabilité individuelle de ceux qui commettent de tels crimes. Compte tenu du temps qui nous est imparti et de vos préoccupations, je vais traiter uniquement de la question de la façon dont les personnes qui commettent ces grands crimes et qui violent les droits de l'homme dans leurs différentes composantes le font à l'occasion de conflits armés internationaux, c'est-à-dire dans les cas où il y a un conflit entre les forces armées de deux États. Et j'essaierai de voir dans quelles conditions les personnes qui peuvent être accusées de tels crimes peuvent être poursuivies. Je laisse donc de côté les conflits armés non internationaux qui paraissent être au second plan de vos préoccupations actuelles. J'enchaînerai 3 points. Premièrement, les États et leurs tribunaux ont la responsabilité première de poursuivre ces violations. Deuxièmement, le statut de Rome, qui définit les plus grands crimes, fixe les conditions dans lesquelles la Cour pénale internationale peut exercer sa compétence à leur égard et les conditions dans lesquelles le procureur de la Cour pénale internationale peut engager des poursuites quand il est saisi et quand il estime être compétent. Enfin, je dirais que la question du crime d'agression reste ouverte, faute de disposer d'une instance judiciaire compétente pour en connaître. Les crimes commis à l'occasion de conflits internationaux sont d'une dimension et d'une nature bien distinctes des crimes ordinaires dont les tribunaux de chaque État ont à connaître dans leur activité ordinaire. Et c'est à chaque État que revient la responsabilité principale de transcrire dans sa législation nationale les engagements internationaux qu'il prend en matière de droits de l'homme et de droits humanitaires pour qu'il puisse lui-même poursuivre ses crimes. Il est donc important que les crimes de guerre, les crimes contre l'humanité et le crime de génocide soient incriminés en tant que tels dans les législations nationales, conformément aux dispositions du statut de Rome, qui en fournit une véritable codification. Disons-le, cette transposition est loin d'être achevée et il existe encore de grandes lacunes, y compris parmi les États qui sont représentés ici. Ceci relève donc de la responsabilité des parlements et vous êtes les mieux placés pour combler ces lacunes qui persistent dans beaucoup d'États. Certains États adoptent en outre des dispositions qui leur permettent de poursuivre des actes commis par des personnes étrangères à leur État en dehors de leur territoire national. C'est ce que l'on appelle la clause de compétence universelle et elle s'applique bien entendu au droit pénal international. Pour que les États puissent pleinement mettre en œuvre leurs responsabilités, il est important qu'ils disposent d'équipes spécialisées, disposant des équipements juridiques, des moyens matériels, techniques, humains, qui leur permettent d'effectuer les poursuites et de poursuivre les crimes commis à l'occasion d'un conflit international. Cet ensemble de tâches est exigeante. Ces tâches sont coûteuses et elles supposent que se manifeste une forte volonté politique de la part des exécutifs et de la part des parlements et que cette volonté politique puisse se poursuivre dans la durée, sur une période longue. Le tribunal pénal international pour l'ex-Yougoslavie, qui avait été créé par le Conseil de sécurité des Nations unies en 1993, n'a pas encore terminé sa tâche 30 ans plus tard. En effet, à la fin du siècle dernier, des juridictions pénales internationales avaient été créées pour créer de certaines situations en ex-Yougoslavie et au Rwanda, avec une primauté de juridiction sur les juridictions nationales. Le statut de Rome est bâti, lui, sur la complémentarité entre tribunaux nationaux et Cour pénale internationale. Son préambule est clair. La Cour pénale internationale, dont le présent statut porte création, est complémentaire des juridictions pénales nationales. Cette Cour a pour connaître des crimes qui ont été commis sur le territoire d'un État partie au statut de Rome, il y en a actuellement 124, ou des crimes qui auraient été commis par un ressortissant de l'un de ces États parties. La Cour n'a vocation à intervenir qu'en dernier ressort, dans les cas où les tribunaux nationaux n'ont pas voulu ou n'ont pas été capables d'exercer des poursuites et de mener à bien ces procès. Le bureau du procureur de la Cour peut être saisi d'une situation par un État partie au statut, par le Conseil de sécurité des Nations Unies, ou il peut se saisir lui-même proprio motu avec l'assentiment des juges de la Cour. Les États non partis peuvent également se soumettre à la juridiction de la CPI pour une situation donnée. Et dans la pratique, ce sont les États qui ont demandé le plus souvent au bureau du procureur de se saisir de situations se déroulant sur leur territoire propre. C'est ce qu'a fait l'Ukraine à 2 reprises, en 2014 et en 2015, s'agissant des crimes qui auraient été commis sur son territoire, bien que l'Ukraine, qui a signé le statut de Rome, ne l'ait pas ratifié. En mars 2022, 43 États partis au statut ont demandé au bureau du procureur de se saisir de la situation existant sur le territoire de l'Ukraine. L'enquête a formellement été ouverte et le bureau du procureur est actuellement en train de mener des enquêtes sur le terrain. Le bureau du procureur dispose d'une large discrétion dans le choix des situations et des affaires qu'il retient. Il entretient un dialogue continu avec les autorités des États où pourraient avoir été commis des crimes relevant de la compétence de la Cour. Il le fait de façon indépendante et impartiale à l'égard des parties au conflit. Ainsi, l'existence même d'une juridiction internationale à vocation universelle, habilitée à connaître des plus grands crimes commis dans les conflits internationaux, permet de mener à bien quelques procès à haute visibilité. Les jugements qui sont rendus par la Cour pénale internationale ouvrent des perspectives de justice aux victimes, ils permettent de définir une jurisprudence et ils peuvent avoir un effet d'entraînement sur les juridictions nationales, même si le nombre de jugements qu'ils rendent reste très modeste à l'égard du nombre des crimes qui pourraient être couverts par la juridiction de la Cour. Enfin, ces jugements ouvrent droit à des réparations qui sont extrêmement importantes pour les victimes des crimes. Ainsi, la complémentarité qui existe de façon positive entre tribunaux nationaux et internationaux permet qu'ils travaillent simultanément et en bonne entente sur les mêmes situations, dans les mêmes États, en partageant leurs informations et en se répartissant les tâches, y compris entre tribunaux nationaux, agissant sur la base, avec des tribunaux nationaux, agissant sur la base de la compétence universelle. C'est ce qui se passe actuellement, par exemple, en République centrafricaine, et cette situation est en train de se reproduire dans d'autres situations, par exemple en Ukraine. Qu'en est-il enfin du crime d'agression? L'article 6 du tribunal militaire international de Nuremberg définit le crime contre la paix comme la direction, la préparation, le déclenchement ou la poursuite d'une guerre d'agression ou d'une guerre en violation des traités, assurances ou accords internationaux, ou la participation à un plan concerté ou à un complot pour l'accomplissement des actes qui précèdent. Les crimes contre la paix ont été considérés comme étant de la responsabilité des personnes en charge de décider ou d'influencer la politique d'un État. Ce crime a été retenu à l'égard d'une partie des personnes condamnées à Nuremberg et à Tokyo après la Deuxième Guerre mondiale. Il a progressivement été reconnu comme relevant du droit international coutumier et il a fait l'objet d'une définition adoptée par l'Assemblée générale des Nations unies dans la résolution 3314, Romains 19. Il pourrait donc être évoqué devant les tribunaux nationaux des États, même si actuellement seulement 32 États ont inscrit le crime d'agression dans leur droit national. Le crime d'agression a été prévu dans le statut de Rome en 1998, puis il a été défini et intégré dans ce statut par des amendements adoptés à Kampala en 2010. Cependant, ce crime ne peut être évoqué à l'encontre des États non partis au statut ou à l'encontre des États partis au statut qui n'ont pas ratifié ces amendements. La Cour pénale internationale ne pourrait en conséquence connaître de tels crimes que dans des cas extrêmement réduits, et je pense que ces cas ne concernent pas les crises qui sont évoquées actuellement devant vous. Il y a donc une lacune en matière de responsabilité du fait de violation des droits de l'homme au sens large en matière de commission du crime d'agression, d'autant que ce crime englobe et nourrit les autres grands crimes commis par le droit international. Pour combler cette lacune, plusieurs propositions ont été faites. Je n'en citerai ici que deux. La première serait de supprimer les restrictions concernant le crime d'agression dans le statut de Rome, ce qui permettrait qu'il soit évoqué à l'encontre des États partis ou des États non partis. Mais cette procédure d'amendement du statut de Rome exigerait une procédure longue dont le résultat est incertain. La deuxième formule que j'évoquerai est celle qui a été retenue par une résolution adoptée par le Parlement européen et par un projet de résolution qui a été soumis à l'Assemblée générale des Nations unies. C'est celle d'un tribunal hybride centré sur les crimes d'agression tels qu'ils pourraient avoir été commis sur le territoire de l'Ukraine. Ce tribunal hybride serait constitué à partir d'un tribunal national convoqué par un État qui serait ensuite internationalisé à l'issue d'une négociation et de travaux préparatoires menés par le secrétaire général des Nations unies qui aurait été mandaté par la résolution adoptée par l'Assemblée générale des Nations unies. Ce n'est pas une formule nouvelle, c'est une formule qui avait été utilisée pour créer les chambres concernant les crimes commis par les Khmers rouges au Cambodge et les chambres spéciales pour le Sierra Leone. Si le projet soumis à l'Assemblée générale des Nations unies était adopté, un délai significatif serait à prévoir là aussi avant qu'un tel tribunal puisse voir le jour, en admettant que toutes les conditions de sa création soient remplies. En conclusion, je dirais que la poursuite des violations des droits de l'homme dans les conditions internationaux dans les conflits internationaux se présente encore comme un chantier qui est porteur de grands espoirs, mais qui en est toujours à ses débuts et qui revêt une grande complexité. Les progrès en la matière resteront très dépendants de l'engagement des États qui doivent agir au premier lieu à travers leurs tribunaux propres ou en soutenant les institutions judiciaires internationales qui requièrent un appui constant et des moyens matériels et juridiques pour travailler dans la durée. Il revient aux parlementaires engagés dans les valeurs de l'OSCE de manifester dans le cadre national leur volonté constante vis-à-vis de ce chantier exigeant s'ils veulent faire reculer l'impunité des plus grands crimes et répondre aux attentes des victimes dans les multiples conflits internationaux que connaît notre monde. Je vous remercie et je suis heureux que cet exposé puisse être complété par celui de Madame la professeure Bilkova.
Thank you, Judge. Now I have the pleasure to pass the floor to Professor Veronika Bilkova, an expert in international law with particular focus on humanitarian and human rights law. Among other responsibilities, Professor Bilkova serves as a member of the Council of Europe's Venice Commission, as well as being on the managerial board of the EU Agency for Fundamental Rights. Of particular relevance to our discussion today, Professor Bilkova brings practical experience as a member of the two OSCE Moscow mechanism missions last year that examined abuses resulting from the war in Ukraine. Thank you for joining us, Professor, and I look forward to hearing your input. Please, you have the floor for 7 minutes.
Thank you very much, Mr. Chair. Good afternoon, dear members of the General Committee on Democracy, Human Rights, and Humanitarian Questions. It is a pleasure for me to take part in this special debate. My speech will indeed primarily rely on the two expert reports entitled Reports on Violations of International Humanitarian and Human Rights Law, War Crimes and Crimes Against Humanity committed in Ukraine. These two reports, as already mentioned, were produced last April and July of 2022 under the so-called OEC Moscow mechanism. And I had the honor to co-author them together with 4 other experts, 2 for the first report, 2 for the second report. I will first briefly introduce the main conclusions we reached in these reports, and I will then mention some legal challenges that we identified while drafting these reports. Before I do so, however, I have to stress that although the reports, technically speaking, only cover the first 4 months of the conflict, that means the period from the 24th of February till the 25th of June of the last year, their findings are unfortunately fully relevant for the subsequent 8 months of the conflict as well. These findings have indeed been confirmed by the preliminary report of the Independent International Commission of Inquiry on Ukraine established within the United Nations, as well as by numerous reports published by NGOs and by media. We were the very first to document what many others have documented since then. So what is it that we documented and we concluded? That's the first part of my speech. Unsurprisingly, the reports found out that serious violations of both international humanitarian law, that is the law of armed conflict, and of human rights law had been committed and have been committed since then in the conflict in Ukraine. These violations encompass, without being limited to, targeted killings of civilians, including journalists and human rights defenders, torture of civilians or prisoners of war, rape of women and girls, abductions of people, or deliberate destruction of civilian infrastructure or of cultural property. Most of these violations occurred in the territories under the effective control and temporary occupation of the Russian Federation, and they are thus largely attributable to Russia. That also means that under the classical rules of the state responsibility, Russia now could be expected to stop committing these violations, to duly investigate those violations which have already occurred, and also to provide reparations to victims. And it is our joint task of us as lawyers and our experts and you as politicians to make sure that Russia lives up to its obligations. The 2 reports also concluded that some of these violations not only give rise to the responsibility of the state, primarily Russia, but they also constitute crimes under international law. That means either war crimes, that is violations of the most fundamental norms of international humanitarian law, such as deliberate targeting of civilians, or crimes against humanity, that is atrocity crimes, such as murder or torture, committed as part of a widespread or systematic attack directed against a civilian population. As we've already heard, crimes under international law give rise to individual criminal responsibility, and their perpetrators should thus and do already or are already held accountable either at the international level, that means before the ICC, or at the national level in Ukraine or in other countries. I have to add that in the reports, we did not deal with the act and the crime of aggression. We, however, found it obvious, and we started from the assumption that the use of force by Russia against Ukraine could indeed and should indeed be qualified as aggression. That brings me to the second part of my speech and to certain challenges that we encountered and identified while drafting the report. I will mention 3 of these challenges. The first challenge relates to the importance and at the same time difficulty to respect the separation between the rules regulating the use of force, so-called jus ad bellum, on the one hand, and the rules applicable during the conflict, so-called jus in bello, especially international humanitarian law. Under jus ad bellum, there is no inequality. That means there is inequality. Russia is considered to be the aggressor. Ukraine is considered to be the victim entitled to act in self-defense. That means that the use of force by Russia is unlawful, the use of force by Ukraine is lawful. That also means that supporting and providing, for instance, weapons to Ukraine is lawful, supporting and providing weapons to the other side is legally problematic, to say the least. This is the use ad bellum where no equality exists. However, this has no impact on the use in bello level. Here, on the contrary, Russia and Ukraine have the same rights and the same obligations under IHL and also more or less under human rights law. If Russia may not use certain weapons, Ukraine may not use them either. If Russia may not target certain civilians or certain objects or certain individuals, Ukraine may not target them either. These get often forgotten or confused in the public debate, and indeed it might seem unjust, but it's a crucial fundamental element of international law. And without that, international law would have difficulties ensuring at least some protection of individuals caught in an armed conflict. So that's the first challenge. The second challenge pertains to the protection of human rights in times of armed conflict. Surprising as it may be, there is still a discussion going on as to whether human rights do apply in times of armed conflict at all, or whether their application is limited to times of peace. When drafting the reports, we were happy to see that even states which have traditionally sided with the latter view, that means non-applicability, seem now able and ready to accept the former view, that means applicability. And it is by far not only and not necessarily on the Russian Federation. We are also pleased to see how many states endorse the broad approach to human rights that we embraced in the two reports. The reports did not limit their attention to the classical civil and political rights, such as the right to life or the prohibition of torture. Rather, the reports also focused on the so-called second generation rights, that means economic, social, and cultural rights, such as the right to health, the right to education, or the right to a healthy environment. And the reports showed how deeply the enjoyment of these rights had been affected by the conflict. And we also focused, and I was very happy to hear that this item is now included in the long-term agenda. We also focused on the position of vulnerable groups of persons, such as elderly people, people with disabilities, or children, because we realized that while everyone was affected by the conflict, the vulnerable groups were affected even more. So this is the second challenge, to realize the importance and the full scope of human rights which apply and may get violated in times of armed conflict. The third challenge, and I will close with that, concerns the accountability mechanisms. We tend to speak about accountability a lot today. Indeed, it's also in the title of today's meeting and of the debate, and rightly so, no doubt. But sometimes we tend to have a rather limited understanding of what accountability or justice means. We tend to focus a lot on perpetrators, and that is fully deserved. It's an important part of ensuring accountability. Yet accountability and justice does not stop there. It's not only by persecuting perpetrators that we will ensure justice and accountability. We need to think about other elements and about other people, especially victims. And we need to take into account that victims are not only those who suffer the consequences directly of these atrocity crimes, but victims are also those who have lost their relatives or their homes, those who are unable to attend schools, or those who have been forced to leave their homes and relocate within Ukraine, or leave Ukraine and relocate elsewhere. At this point of time, international law is relatively well equipped, even if it was described just as a chantier, but it's relatively well equipped to deal with perpetrators. We have rules, we have institutions such as the ICC, we have historical precedents. The situation is much worse with respect to victims. The rules are still unclear, there are no special general institutions, and the practice is scarce and inconsistent. So maybe to conclude on an at least a bit optimistic outlook, we could take the current conflict as an opportunity to start thinking seriously, not only about how to hold perpetrators accountable, but also how to help victims. After all, many of them are now not only in Ukraine, but on the territory of many of the countries represented here in this room. Thank you for your attention, and I would be happy to address any questions you may have, not only with respect to the OEC Moscow mechanism.
Thank you, Professor. We now come to debate on the topic. We have many speakers registered, so we will need to be efficient with our remaining time. And I myself promise to pronounce all your last names correctly. I'll try my best at least. The first speaker on my list is Sheila Jackson-Lee from the United States, followed by Ms. Marta Freitas from Portugal.
To my colleagues of the OSCE EPA, right now as we speak, Russia is perpetrating genocide. Right as we speak, Russia is abducting more than 17,000 children. And the Ukrainian people are asking that our parliaments have an emergency call regarding the kidnapping of Ukrainian children. Our Vice President Harris, indicated that this is now crimes of war crimes, but it is also a humanitarian crime. That is why we're here today. Ukrainian children are being forcibly taken to Russia, put up for a phony adoption into Russian families. This is genocide, according to the 1948 Genocide Convention. We must understand this, we must say it. And as has been said by our speakers, we must look for prosecution, but we must also look for condemnation. They are reprogramming these children. Many of these children are now being used to act in place of Russians in this aggressive war that will be noted tomorrow. This is aggression. This is Russia's war against Ukraine. The reprogramming is devastating. It is genocide by taking the culture away from these wonderful children, not allowing them to know their language or their culture. And so many of us were able to see in those early days children alongside of dead parents. But that does not mean that the people of Ukraine should not take care of their precious resources. That is the human life of their children. Their children should be able to be in Ukraine, re-educating them, putting them in orphanages, the horrors of the killing of children, placing them in the basement, as this picture shows, the basement of a theater, of a school, and not letting these children, these babies come out, people dying amongst them. This is clearly genocide. And I might say that Russia's explanation is ridiculous, that they're abducting children because they want to give them legal guardians. We must stand united as we come out of this with children on our mind. We must look at establishing a registry. We must recognize that the children are suffering serious injury and trauma due to Russia's genocidal war. And we must understand that they have violated the laws of land. If you, of all of our lands, if you know that the repression of Russia at home, taking hostages, as we have one of ours still remaining, Paul Whelan, then you know that they are not against violence abroad. So I ask that we do several things. One, that our parliaments, our congresses come back with a call, an emergency call about Russian kidnapping of children. I think we need to declare that it is genocide so that the world and our constituents will know the horrors of what is going on. We should use Mariupol as the example of a devastated city where the children were snatched. We should say that their cultural heritage is going, and we must demand reparations with the assets that Russia has around the world. We must demand the reprogramming and reutilization of those dollars. Remember, as we speak today, Russia is perpetrating genocide. They are taking children, children are dying, children are being traumatized. Anything that we leave here with should be the protection of children. I thank you very much, Mr. Chair, for your kindness and your indulgence. I yield back.
Thank you. I give the floor now to Ms. Marta Freitas from Portugal, followed by Ms. Barbara Bartusz from Poland.
Thank you, President. The invasion of Ukraine began on February 24, 2022, 1 year ago. and the rights of the Ukrainian citizens have been constantly violated. Faced with the scenario, Portugal acted quickly, while his citizens promptly offered to help, shelter, employ, and teach the Portuguese language to Ukrainian refugees that arrived in the country. New bridges of communication were established and support measures implemented by the Portuguese government. Portugal has approved more than 58,000 temporary protection status to people that fled the war in Ukraine. 25% of the total are minors. It was also noted that some of these minors arrived not accompanied by their parents or a legal representative, which puts these children into a situation of vulnerability and possible danger. Therefore, specific measures have been outlined for the reception, follow-up, and social support of these minors. Several support measures are adopted in areas such as housing, social support, health, humanitarian, education, and shelter aids. Most of the refugees in our countries are women and children, which slows their integration into the labor market due to the lack of family support to take care of their children. It is therefore necessary to maintain a continuous support network to allow these women to work and support their children. Despite all of our support, we are still witnessing the hardships of a community, trying to adapt to a new country and to a temporary situation with no end in sight. It is important that we remain aware of the needs of the Ukrainian women and children in this hard moment of their lives. Often we assume that the hardest part of running away from a conflict is to leave the affected area, but to women, it's so much more than that. Women in this situation are often found in a position where they are forced to accept precarious conditions and abuse that will otherwise not happen. I'm not referring only to livelihood issues. Ukrainian women are also vulnerable to gender-related risks, such as human trafficking, sexual violence, and lack of access to essential goods, as the United Nations has warned. It is important to support these women and children in each and every one of countries, while we continue our efforts towards peace, so that we can guarantee the future of Ukraine and the future of the whole of Europe. Thank you.
Thank you. Next speaker is Ms. Barbara Bartusz from Poland, followed by Mr. Stefan Demilly from France.
Mr. Chairman, dear colleagues, the Russian war against Ukraine shows total lack of respect for international humanitarian laws and human rights laws. The Russian forces have committed horrific crimes that include killing women and children, torture, and sexual violence. This is not acceptable in a modern world. This needs strong and open international disapproval. As a neighbor and close friend of Ukraine, we see the dramatic humanitarian consequences of this war. We believe that it is now very important to document how Russian aggressors violate human rights in Ukraine. I believe we should work to find the most effective way to judge Russia's aggression. Criminals must be held responsible. This should now be a priority for the international community. The Russian Federation must be held accountable for violating international laws, including human rights laws in Ukraine. At the same time, we are concerned with the critical situation of human rights in Belarus, and that this country's authorities support the Russian military aggression against Ukraine. We are alarmed by the increasing numbers of political prisoners. I believe that our Commission should make sure that every country in the OSCE respect the promises made in this forum. Also, the obligations to protect national minorities. Mr. Andrzej Poczobut, journalist, a member of the biggest organization of the Polish national minority in Belarus, arrested by the Belarusian authorities over 2 years ago, still remains in prison. The aggressive Russian war against Ukraine shows how delicate stability is in our region. It is important that the international community, including the Parliamentary Assembly, stay united and protect human rights. Thank you.
Thank you. The floor goes now to Mr. Stéphane Demy from France, followed by Kyriakos Hadjiani from Cyprus.
Merci, Monsieur le Président. Vladimir Poutine a donné l'ordre d'attaquer l'Ukraine le 24 février 2022. Il y a donc effectivement presque un an jour pour jour. C'est un triste anniversaire. Le Haut Commissariat des Nations Unies aux droits de l'homme a enregistré au total près de 20 000 victimes. Un chiffre probablement inférieur à la réalité, comme l'a très bien dit tout à l'heure Matteo Mecacci. Cette invasion viole la Charte des Nations Unies et constitue un crime d'agression au regard du droit international. Établir des faits et récolter des preuves est aujourd'hui primordial pour définir avec certitude si le droit international humanitaire a été violé. Depuis près d'un an, les attaques contre les infrastructures civiles et les civils eux-mêmes sont constantes. À cela s'ajoutent, nous le savons, les actes de torture et la disparition de personnes détenues. Les responsables de ces crimes devront rendre des comptes de ces violations graves du droit international devant les juridictions compétentes. Or, ni l'Ukraine ni la Russie ne sont signataires du statut de Rome de 1998 qui a créé la Cour pénale internationale, même si l'Ukraine a reconnu la compétence de la Cour. Un procès international via la CPI est-il possible ou peut-il être rendu possible alors que la Russie n'est pas signataire du statut de Rome? C'est ma première question. Vous l'avez dit, monsieur le juge, le temps du droit international pénal est un temps long, parfois trop long. Les responsables ne sont souvent jugés quand ils le sont que très longtemps après les faits, quand ce n'est pas, malheureusement, de façon posthume. Alors, comment favoriser la protection dans le temps des preuves et des témoignages? C'est ma deuxième et dernière question.
Thank you. The next speaker is Mr. Kyriakos Hadjiani from Cyprus, followed by Mr. Bob Stewart from the United Kingdom.
Thank you very much. Allow me to express my great sympathy to the people in Turkey and Syria for the big earthquakes, which we also experience in Cyprus. The drama of the people in the affected areas is our drama, and we feel the pain. At the same time, our sympathy to the organized civil society that strives to help people in every way. Dear colleagues, after a year of war in Ukraine, all signs point to more misery with no end in sight. The war that began a year ago has killed thousands, has forced millions to flee from their homes, has reduced entire cities to rubble, and we all fear that the conflict could continue much longer, having an even greater humanitarian impact. The human dimension is an internal part of the OSCE comprehensive security concept, and we, as members of the OSCE Parliamentary Assembly, have to ensure that the human rights approach is kept at the center of our efforts. The opening of investigations by the International Criminal Court into alleged war crimes and crimes against humanity is a necessary development. Those responsible must be held accountable. War crimes, crimes against humanity, and other gross violations of human rights can undermine any peace process. In the aftermath of such terrible events, it is essential to establish the truth about the international crimes and gross violations that took place. perpetrators to account significantly contribute to providing a sense of closure and facilitates diplomatic efforts and processes to find stable and just political solutions to international conflicts. Cyprus knows all too well the humanitarian impact of war. We therefore stand by Ukraine and its people upholding the same international law principles that are being flagrantly violated in Cyprus for 48 years. Despite the fact that Cyprus did not witness the same resolve on behalf of the international community, we will continue to do so steadfastly. In any case, double standards in investigating alleged war crimes or other humanitarian law violations must cease for the benefit of international peace and justice. Thank you very much.
Thank you. The next speaker is Mr. Bob Stewart from the United Kingdom, followed by Mr. Daniel Fessler from Switzerland.
Thank you, Mr. Chairman. I want to talk about bringing war criminals to justice. 30 years ago, I was the British United Nations commander in Bosnia. I identified genocide in the village of Armici in April 1993, and I brought it to the attention of the world media. Personally, with my soldiers, we buried over 100 victims in a mass grave. I lost one colleague while doing so, shot. Since then, I have given evidence in 5 war crimes trials at the International Criminal Tribunal for the former Republic of Yugoslavia. I really want to make 2 points which really are questions. We never got more than a small proportion of Nazi war criminals into court at the end, Nazi and Japanese war criminals into court at the end of the Second World War. A very small proportion were brought to trial. How can we do that with the huge number of atrocities that have occurred in Ukraine? And my second question is, how can we bring top-level war criminals to trial, which would probably require regime change in Moscow? In fairness, this is not without precedent. After all, a change of government in Serbia allowed the ICTY to apprehend Milosevic. Thank you, Mr. Chairman.
Thank you. Next speaker is Mr. Daniel Fessler from Switzerland, followed by Mr. Mark Demesmaker from Belgium.
Geschätzte Kolleginnen und Kollegen, die Schweiz hat sich der dauernden Neutralität im Sinne des Haager Abkommens von 1907 verpflichtet. Militärisch begünstigt sie daher keine Kriegspartei. Neutralität bedeutet jedoch nicht Gesinnungsneutralität. Als Vertragspartei des Statuts von Rom wird sich die Schweiz auch in Zukunft und mit aller Kraft dafür einsetzen, dass zumindest die 4 Kernverbrechen des Völkerstrafrechts, nämlich Völkermord, Verbrechen gegen die Menschlichkeit, Verbrechen der Aggression sowie Kriegsverbrechen mit aller Konsequenz strafrechtlich untersucht und verfolgt werden. Ich nutze die Anwesenheit von Vertretern der Russischen Föderation mit einer an sie gerichteten Erklärung. Sie unterstützen die Propaganda ihres Regimes, obwohl sie, wenn sie ehrlich wären, ganz genau wissen, dass Russland seit dem völkerrechtswidrigen Angriff auf die Ukraine jeden Tag unzählige Verbrechen gegen Kernbereiche des Völkerrechts begeht und Menschenrechte auf gravierende Weise verletzt. Das sind Verbrechen, die schon im Ansatz durch nichts zu rechtfertigen sind. Dafür verantwortlich sind nicht nur die Befehlshaber und Soldaten auf dem Schlachtfeld, sondern mindestens so sehr die politischen Entscheidungsträger, das heißt auch Sie. Sie müssen wissen, Die Tatsache, dass die Russische Föderation ihre Unterschrift unter das Rom-Statut zurückgezogen hat, darf die Verantwortlichen nicht davor schützen, zur Rechenschaft gezogen zu werden. Die Schweiz wird sich für eine strafrechtliche Verfolgung einsetzen, denn wir stehen als neutraler Staat immer und uneingeschränkt auf der Seite des humanitären Völkerrechts und der Menschenrechte. Die Schweiz ist militärisch neutral, sie wird aber beim humanitären Völkerrecht und bei den Menschenrechten immer ihre Werte vertreten. Besten Dank.
Thank you. Now the floor goes to Mr. Mark de Mesmaker from Belgium, followed by Mr. Don Davis from Canada.
Thank you. And I want to join my colleague from the United States on the topic of the abduction of children, and I would like to add some things. Thousands of Ukrainian children have been abducted and deported to the Russian Federation and illegally adopted there. And there can be no excuse for abduction of children from parents and their nation. And moreover, this is prohibited by the 1948 United Nations Convention on the Prevention and Punishment of the Crime of Genocide. The deportation of Ukrainian children to Russia and attempts to brainwash them, removing their language and culture, is a genocidal crime that calls for prosecution. The official policy of the Kremlin is being vigorously pursued by the Russian so-called Children's Rights Commissioner, Ms. Maria Lvova-Belova, who openly advocates stripping children of their Ukrainian identities and teaching them to love Russia. For this, I think, but maybe the judge can clarify that, for this she can face charges as a war criminal, and she is on the sanctions list of several countries already. I see numbers up to 14,000 Ukrainian children who have been taken by Russia without their parents. And some history. The provision of the Genocide Treaty was adopted in the shadow of Nazi atrocities, including a scheme directed by Heinrich Himmler to snatch children from Poland and place them in German orphanages or with German families to be raised as Germans. Nazi methods conducted by Russia, while they themselves justify their failed attempt to conquer Ukraine by the need of denazification. Oh, irony. The first convictions at the Nazi war crimes trials were for child abductions. I hope history can repeat itself for the Kremlin's war crimes. And in the meantime, we should take action to focus attention on the fate of these children. In May last year, the Office of the OSCE Special Representative and Coordinator for Combating Trafficking in Human Beings and the Special Representative of the UN Secretary General organized a roundtable on violence against children with the support of the OSCE Project Coordinator in Ukraine. Focus was the protection of refugee children in need of protection in countries of transit or destination, and this is my appeal now. Now is the time to also focus on the thousands of abducted Ukrainian children. They need to return home, to their homeland, to their parents. It is cruel not to do so.
Thank you. Mr. Don Davis from Canada, the floor is yours. You will be followed by Lucy Potuchkova from Czech Republic.
Honorable Chair, fellow parliamentarians, this debate occurs in the serious context of the present war of aggression commenced by Russia against Ukraine and amidst mutual allegations of war crimes and crimes against humanity. However, let us be well aware that there have been and are now other unjust conflicts, wars, and use of violence being conducted by numerous states against others, both in Europe and beyond. This reality means that what we are discussing today has broad and lasting implications. The foundational concepts in the matter before us have been well established by the Nuremberg Principles. With these principles, the concepts of individual criminal accountability for crimes under international law, an end to impunity, equality before the law, and fair trial rights were universally recognized. More fundamentally, the crimes against peace, war crimes, and crimes against humanity were defined. What do these mean for the present debate? It means that organizations like the OSCE must at all times champion respect for the rule of law, equality, and justice. We must resist the calls for the assignment of guilt before trial, trial by media, and rise above the contamination of justice by politics. It means that all countries who wish to be considered to be responsible members of the international community must be ceaselessly pressured to sign and ratify the Rome Statute and return to the jurisdiction of the International Criminal Court if we are to replace the rule of force with the rule of law. We will not end war crimes unless and until we construct effective methods of accountability and for all who commit them. For countries to respect international law, it must be seen to be applied fairly and consistently. This means that international law must apply to every country in all circumstances. We cannot have one standard for our adversaries and another for our allies. Finally, I wish to add my voice to those who believe that the OSCE must preserve its unique role as a place of dialogue at all times for all members, no matter the circumstances. I believe this is especially the case in times of serious conflict and danger. Peace and security demand it, and the common people that we represent deserve no less. Thank you.
Next speaker is Ms. Lucy Patuchkova from Czech Republic, followed by Ms. Pia Kauma from Finland.
Thank you, Mr. Chair. Dear colleagues, I would like to mention one of the activities that the Czech Republic has organized in the field of justice and violation of human rights. During an open hearing that took place in the Chamber of Deputies in October last year, we gave a full floor to the witnesses of crime of war and atrocities committed on the occupied territories of Ukraine. We are speaking, for example, about deportations, or let's be frank, hijacking of Ukraine citizens, including children, to Russia, where they are raised and used for Russian propaganda. We heard terrible stories of women and young girls, and all these stories should be heard, recorded, and fully documented. In this connection, I would like to point out that the Czech Republic strongly supports establishing of the Special International Tribunal that would focus on the investigation of the consequences of the aggression triggered by the Russian Federation in Ukraine. The Czech Republic participates in the sessions of the so-called core group, composed of international legal experts, which coordinates the necessary steps in these investigations. The first session of this group took place in Prague just a couple of weeks ago. We are not naive, and we are certainly aware how tricky it is to deal with the question of immunity of the top representatives of the Russian Federation. Nevertheless, this should not discourage us from our efforts to enforce justice for victims and punishment for violators. Finally, I would like to specifically express my deep thanks and gratitude to the Moscow Mechanism mission, namely Professor Veronika Bielková, for her excellent, objective, and detailed reports on the violation of human rights in Ukraine. Thank you for your attention.
Thank you. The floor now goes to Ms. Pia Kauma from Finland, followed by Mr. Ahmet Arslan from Turkey.
Mr. President, dear colleagues, we must stay united and help Ukraine by all possible means. Let me inform you that my country, Finland, has today decided to send more weapons to Ukraine, including Leopard 2 tanks. The use of weapons was never meant to be a part of comprehensive security structure of the OSCE countries. However, how else do you stop a country that brutally murders children, women, and wounded civilians without any regard for international commitments and human rights? Russia commits war crimes before our very eyes. On the 2nd of February, a Russian missile was fired on a group of medics helping an elderly civilian in Bakhmut who had been wounded in the fighting. The 2 killed and 5 wounded in this cowardice attack were all civilians carrying no guns and risking their lives to help a victim of war. The attack was filmed, which adds to the increasing amount of evidence of Russia's war crimes. War criminals must be held accountable and be punished. Only then can we even think of building sustainable possibilities for peace and reconciliation when Ukraine so decides. Let me also salute Ukraine for its commitment to democracy. The Ukrainian parliament has continued to convene. The fundamentals of the society have kept running. President Zelensky has acted against corruption. On its EU road, Ukraine has shown its ability to pass reforms even in horrible circumstances. This gives me hope. One day, when this war is over, we will start reconstruction. Ukraine will get a new start, and Ukrainians will get the free democracy they deserve.
Thank you. Before I give floor to Mr. Ahmet Arslan from Turkey, on behalf of this committee, I would like to extend condolences to the families of the victims of the devastating earthquakes that hit Turkey several weeks ago. We wish speedy recovery to those injured, and our thoughts and prayers are with the Turkish people. The floor goes now to Mr. Ahmet Arslan, followed by Mr. Pere Joan Pons from Spain.
Sayın Başkan, kıymetli meslektaşlarım, Türkiye'de gerçekleşen deprem felaketinin ardından her türlü taziye ve desteğini eksik etmeyen ülkelere, sivil toplum kuruluşlarına, arama ve kurtarma çalışmalarına katılanlara, kıymetli meslektaşlarıma en içten şükranlarımı sunuyorum.
Esteemed President and valuable colleagues, I would like to express my sincere gratitude to those participating in search and rescue efforts, all those countries, civil society organizations, and my esteemed colleagues for their condolences and support that they had extended towards Turkey after the earthquake disaster.
Buradan hayatını kaybeden vatandaşlarımıza Allah'tan rahmet, ailelerine ve sevdiklerine sabır, yaralananlara da acil şifalar diliyorum. Sorunları bir kenara bırakarak insani temelli birlik ve beraberliğin önemini bir kez daha görmüş olduk.
I wish God's mercy to our citizens who lost their lives, patience to their families and loved ones, and speedy recovery to those who were injured. We have once again witnessed and seen the importance of unity and solidarity among our people, shown by leaving their problems aside.
İster savaş, ister barış zamanında olsun, insan hakları ihlalleri karşısında hesap verilebilirliğin sağlanması, insan hakları ve temel özgürlüklerin korumaya yönelik gerekli çabaların kritik bir parçasıdır.
Ensuring accountability for human rights violations, whether in time of war or peace, is a critical part of overall efforts to protect human rights and fundamental freedoms.
Silahlı çatışmalarda ağır uluslararası insancıl hukuk ihlallerinin yanı sıra yaygın ve sistematik farklı uluslararası insan hakları ihlallerinin de yaşandığını maalesef dünyanın farklı yerlerinde görmekteyiz.
Unfortunately, we observe in different parts of the world that there are widespread and systematic violations of international human rights, as well as serious violations of international humanitarian law in armed conflicts.
Özellikle son 30 yılda daha fazla ülkede şiddetli çalışmaları yaşandığı görülmektedir. Bu tür ihlallerin sorumlularından hesap sorulmasını teminen gerekli tedbirlerin alınması esastır.
Especially in the last 30 years, it is seen that there have been violent conflicts in more countries. It is essential to take the necessary measures to ensure that those responsible for such violations are held accountable.
Bunun için de uluslararası hukukla uyumlu mevzuatın yanı sıra etki ve etkili hesap verilebilirlik mekanizmalarının sahip olunması önemlidir.
For this, it is important to have effective and efficient accountability mechanisms set up, as well as legislation that is compatible with international law.
Ulusal ve uluslararası istişareler ile birlikte bu mekanizmaları geliştirirken kadınlar ve çocuklar da dahil olmak üzere mağdurların katılımına, kapasite geliştirme desteğine, mali ve maddi kaynakların seferber edilmesine önem verilmelidir.
In developing these mechanisms together with national and international consultations, emphasis should be placed on the inclusion of victims, including but not limited to women and children, and support for capacity building and the mobilization of financial and material resources. Thank you very much.
Thank you. Next speaker on my list is Mr. Pere Joan Pons from Spain, followed by Mr. Davor Bernardic from Croatia.
Buenas tardes a todos y a todas. En primer lugar, quería hacer una reacción a una de las cosas que ha dicho el presidente de la Comisión, que ha hablado de Ana Politkovskaya, que fue asesinada en Moscú. Yo trabajé con Ana Politkovskaya del 2002 al 2004, en la Segunda Guerra de Chechenia, y lo que me enseñó es que tenemos que ser parte de la solución siempre. Parte de la solución siempre. Creo que como parlamentarios y parlamentarias tenemos que ser parte de la solución y me uno en algunas de las cosas que ha dicho el parlamentario de Canadá. Primer punto. Segundo punto, hoy el presidente de mi país está en Kiev y como ha dicho el juez, forma parte de los 43 países que se ha dirigido hacia la Corte Penal para que se examinen los posibles y presuntos crímenes de lesa humanidad, de guerra, incluso de genocidio y por tanto creo que no somos sospechosos de ser bien claro dónde estamos y por tanto condenamos claramente la agresión de Rusia a Ucrania. Pero bueno, aquí todo el mundo habla del elefante en la habitación y sí que me gustaría que ese elefante, que creo que está desnudo y que creo que es a la vista de todos un estado muy cercano a ser un estado paria, sí que me gustaría decir y contestar a dos preguntas. Una, ha generado mayor unidad global que nunca. Y en relación a la seguridad europea, sí que me gustaría decir que en relación a 2014, no al ataque desde hace un año, hace 10 años, en 2014, Europa estaba sumida en una crisis existencial, con propias palabras de Juncker. Hoy hemos tenido una respuesta humanitaria, política, militar, solidaria, incluso con los ciudadanos y ciudadanas ucranianas, que no tiene precedentes. Por lo tanto, creo que la respuesta ha sido excepcional. Pero me gustaría terminar con una pregunta para los dos ponentes sobre el estado de la democracia. Es decir, en un marco frágil de democracia, en el que la democracia es atacada internamente y externamente, ¿ustedes creen que ese marco frágil también peligra para los derechos humanos y el marco en el que ustedes han hablado? Muchísimas gracias.
Thank you. The floor goes now to Mr. Davor Bernardic from Croatia, followed by Mr. Bjorn Söder from Sweden.
Thank you, Mr. President. I would like, first of all, express my deepest condolences to Turkish delegation for this tragedy of people in earthquake in Syria and Turkey. And this tragedy reminded us all of huge suffering of people, just like people in Ukraine suffer every day. Unprecedented and unprovoked aggression of Russia against Ukraine made millions of people suffer. It's clear that Russia strongly violated and still breaks international laws and human rights. Crimes against humanity, raping women, adopting children, killing innocent people, that's reality in Ukraine today. It was reality in Croatia and Bosnia and Herzegovina during the 90s due to the Serbian aggression. So the solidarity with the Ukraine was for us never the question. I would draw some parallels. Important thing is that only because Croatia changed situation in battlefield, Serbs accepted negotiations, and that led to peace agreement and universal jurisdiction of International Criminal Court. Trials at ICC were, as Marc Perrin de Brichambault said, was highly visible trials that gave confidence and showed people in Croatia and Bosnia that criminals should face the justice. Even though criminal court on Yugoslavia haven't finished its job yet, after almost 30 years, because of that court and because of lots of war criminals like Slobodan Milosevic faced the justice, people felt some justice, and that's the first step towards reconciliation. So necessity of international jurisdiction and criminal court is very important in this specific war and this specific issue. And because of that, relations of Croatia and Serbia are not anymore main topic of the international community.
Thank you. Next speaker is Mr. Björn Söder from Sweden, followed by Ms. Renata Alt from Germany.
Thank you, Mr. Chair. The last centuries have laid the groundwork for individual freedoms and political rights that we as citizens enjoy today. The right to freely express ourselves and contribute to the political changes in the nations that we live in have strengthened our communities and made us all prosperous. It is our responsibility to continue building a strong foundation on which these norms can continue to prosper. The main focus for security issues in Europe has during the last year been on Ukraine, rightfully so. While we encourage and support Ukraine to the fullest, we must also remember the other security-related questions our organization deals with. Lukashenko's tyranny in Belarus must not be forgotten. The last so-called election in Belarus shows how authoritarian politicians stay in power at the cost of people's fundamental freedoms. Lukashenko has for almost 30 years cemented his position as a dictator and imprisoned oppositional movements against his tyranny. In July and August last year, monuments and grave sites of Polish resistance fighters during World War II were vandalized and demolished. Its severe mistreatment is a way for Lukashenko to dismiss Polish resilience and the great struggle the Poles faced when invaders from East came. Lukashenko's actions cannot under any circumstances be tolerated. We must provide the necessary resources so it becomes possible for people to contribute to a prospering community. Other political deadlocks in Europe, like the one in Nagorno-Karabakh, need to be dealt with. As it stands today, the Latching corridor is not a sustainable solution, as we see people in need not getting the necessary resources. Food, medicines, and other resources are not being delivered to the area, creating a great humanitarian catastrophe. It is a most dire situation and a clear violation against the trilateral agreement between Azerbaijan, Armenia, and Russia created in 2020. It is the responsibility of our organization to create a stronger foundation on which discussions can be taken to resolve the issue. If we do not do this, thousands of people will continue to suffer in Ukraine, Belarus, and in Nagorno-Karabakh. It is time to take action and to seriously consider what we can be done to secure the rights and health of the people in the OSCE region. Thank you very much.
Thank you. Now I call upon Ms. Renata Alt from Germany, followed by Ms. Mirgul Tamirbayeva from Kyrgyzstan.
Liebe Kolleginnen und Kollegen, Wladimir Putin hat die Entschlossenheit und Courage der ukrainischen Bevölkerung unterschätzt. Je verzweifelter die russische Führung aber ist, desto schwerwiegender sind die Menschenrechtsverbrechen an der ukrainischen Zivilbevölkerung. Schwerste systematische Menschenrechtsverbrechen wie die Entführung von über 17.000 Kindern aus der Ukraine, die Vergewaltigung von Frauen sowie Folter und Mord sind zentraler Teil der russischen Kriegsführung. Es handelt sich nicht nur um einen Angriff auf die Menschenrechte, sondern um einen Angriff auf die Menschlichkeit, um einen Angriff auf die freiheitlichen Werte. Diese Werte verteidigt die Ukraine derzeit und diese Werte müssen auch wir verteidigen. Dafür braucht es eine effektive strafrechtliche Verfolgung der Menschenrechtsverbrechen mit einer noch engeren Zusammenarbeit der internationalen Gemeinschaft. Ob vor dem Internationalen Strafgerichtshof oder vor einem hybriden Sondertribunal. Es muss unser Anspruch sein, alle begangenen Verbrechen aufzuklären. Alle Verantwortlichen müssen ausnahmslos zur Rechenschaft gezogen werden. Kein Menschenrechtsverbrechen darf straffrei bleiben. Das Bestehen der Völkerrechts diesbezüglich an seine Grenzen. Der Internationale Strafgerichtshof verfügt im Falle der Ukraine für die Völkerrechtsstraftaten, Verbrechen gegen die Menschlichkeit, Kriegsverbrechen und Völkermord über eine uneingeschränkte Zuständigkeit. Dies gilt jedoch nicht für das Verbrechen der Aggression, wie Frau Professor Bilkova erwähnt hat. Aber eine drohende Straffreiheit muss unbedingt verhindert werden. Deshalb müssen die Kompetenzen des Internationalen Strafgerichtshofs gestärkt und besonders im Bereich des Verbrechens der Aggression durch eine Änderung des römischen Status erweitert werden. Wir müssen die Ukraine weiterhin vehement unterstützen für eine europäische Perspektive, die Freiheit, die Menschenrechte und die Souveränität sowie die territoriale Integrität der Ukraine. Ich richte jetzt meine Worte an die Vertreter der russischen Delegation. Beenden Sie diesen unsäglichen Krieg. Was tun Sie den kleinen unschuldigen Kindern und den Menschen an? Ich appelliere an Ihr Gewissen. Stoppen Sie diesen Krieg und zwar gleich jetzt.
Thank you. The floor goes now to Mr. Mirgul Tamirbayeva from Kyrgyzstan, followed by Mr. Boris Dietrich from Netherlands.
Спасибо, господин председатель. Уважаемый господин председатель, уважаемые коллеги, позвольте мне от имени делегации Жукурку-Кенеша Кыргызской Республики приветствовать председателя комитета, докладчиков и всех приглашенных гостей сегодняшнего заседания. В начале выступления позвольте выразить глубокие соболезнования нашим турецким коллегам в связи с многочисленными человеческими жертвами и пострадавшими в результате масштабного землетрясения в юго-восточных провинциях Турции. Желаю терпения родным и близким погибших и скорейшего выздоровления пострадавшим в результате стихийного бедствия. Уважаемые коллеги, хочу отметить, что в нашей стране действует более 6 тысяч неправительственных организаций, правозащитники, институт омбудсмена, уполномоченный по правам ребенка, бизнес-омбудсмен, совет по правам женщин, детей и гендерного равенства при Турага Жугорку Кенеша Кыргызской Республики, Национальный совет по делам женщин и гендерному развитию при Кабинете министров и Национальный центр по предупреждению пыток и других жестоких, бесчеловечных или унижающих достоинства видов обращения и наказания. С 2013 года функционирует Координационный совет по правам человека при Кабинете министров Кыргызстана, который осуществляет мониторинг деятельности государственных органов по реализации рекомендаций ООН по правам человека. На прошедшей сессии Генеральной Ассамблеи ООН Кыргызстан был в 3-й раз избран членом Совета по правам человека на 2023 и 2025 годы. Мы намерены дальше вносить свой вклад в работу этого важнейшего и востребованного органа ООН. Уважаемые коллеги, в Кыргызстане роль женщин и вопросы гендерного развития включены в важнейшие документы нашей страны, в том числе в Национальную стратегию развития Кыргызской Республики на 2018 и 2040 годы. Уважаемые коллеги, в заключение хотелось бы отметить, что парламентская ассамблея ОБСЕ остается нашим приоритетным партнером. Мы всегда открыты к любому диалогу и надеемся на продолжение наших партнерских и теплых отношений. Благодарю всем за внимание.
Thank you. The next speaker on my list is Mr. Boris Dietrich from Netherlands, followed by Ms. Lita Galsyan from Armenia.
Dear fellow members of parliament, 1 year ago, a dark period started by the aggressive war Russia waged against Ukraine. It's a gross violation of international law, international human rights law, international humanitarian law, and of course, the principles of the OSCE. And let's not forget, it's also a grave and gross violation of basic human decency. The blatant attack on Ukraine, a sovereign country, and all reported human rights abuses against Ukrainian children, like abduction, against women, like rape, and against men in Ukraine, call for accountability of Mr. Putin and also his enablers in his administration, his enablers in the Duma, and his enablers in the Russian society at large. No impunity for war crimes, no impunity for crimes against humanity, no impunity for genocide, no impunity for crimes of aggression. Justice should be served so that new generations will realize you cannot get away with these kind of crimes. Victims deserve it. And the Dutch delegation also would like to highlight that we cannot accept that Russian propaganda and Russian lies and its curtailing of the freedom of speech and other civil rights of Russian citizens opposing Mr. Putin's war. Russia should stop this. We support Ukrainian government and the Ukrainian people. Thank you.
Thank you. The floor goes now to Ms. Lita Galsyan from Armenia, followed by Mr. Haidu Gabor from Romania.
Dear colleagues, With due respect towards the victims of conflicts, I have to speak about the severe humanitarian and security challenges that Armenia and Nagorno-Karabakh are currently facing. At this moment, while we are discussing human rights abuses during times of conflict, Azerbaijan is continuing to violate the provisions of November 9 declaration. While our colleague from Azerbaijan is misleading us, stating that there is no blockade, yesterday, the International Court of Justice obliged Azerbaijan to ensure unimpeded movement along Lachin corridor. Since December 2022, the only road of life of Karabakh is illegally blocked by Azerbaijan. In fact, Azerbaijan is implementing policy of ethnic cleansing, keeping us as hostages 120,000 indigenous Armenians of Nagorno-Karabakh. The return of tens of thousands of displaced Armenians is far from being implemented. Armenian prisoners of war and civilians are still being held illegally in Azerbaijan. More than 50,000 immovable Armenian historical and cultural monuments are currently under threat. Azerbaijan impedes international organizations' missions visits to the region. Meanwhile, in the occupied territories of Nagorno-Karabakh, Azerbaijan is destroying or misappropriating the Armenian historical and cultural heritage. Dear colleagues, peace imposed by force and aggression cannot ensure human rights, stability, and peace. The genocidal policy of Azerbaijan is coming to prove that the right of self-determination of the people of Karabakh has no alternative. I call on my colleagues to stand up for the Helsinki principles. Now is the time for action. Time for rejecting the policy of double standards and achieving equal results for all OSCE members. This is the way to restore trust towards OSCE and other international organizations. Thank you.
Thank you. Mr. Haidu Gabor from Romania, the floor is yours now. You will be followed by Ms. Rosemary Moody from Canada.
Dear colleagues, Romania is joining all efforts of the international community in making those responsible of all these terrible crimes in Ukraine accountable for their acts, including within the US OSCE as one of the participating states that invoked the Moscow mechanism. Dear colleagues, we were one of the initial 40 states that referred the situation in Ukraine to the prosecutor of the International Criminal Court. We strongly support the activity of the International Criminal Court, who is acting to investigate all war crimes, crimes against humanity, and crimes of genocide. Furthermore, our government made voluntary financial contribution in response to the prosecutor's appeal to states to help with the overall increased workload of this office. Moreover, Romania offered a multi-layer support for Ukraine, including for refugees, with more than 3.4 million Ukrainian citizens entered our country and more than 107,000 remain. Respect for international law is a fundamental pillar of Romania's foreign policy. We trust in the fundamental role that international law plays in ensuring justice, peace, and stability. In this spirit, Romania is playing its part as a responsible and credible actor. And let me add, dear colleagues, and let me express deep condolences to our Turkish colleagues for the human losses and sufferings caused by the natural disaster.
Thank you. Next speaker as announced is Ms. Rosemary Moody from Canada, followed by Mr. Robert Adderholt from the United States.
Honorable Chair, fellow parliamentarians, Canada strongly condemns Russia's unprovoked and unjustifiable invasion of Ukraine, actions that contravene nearly all the principles and commitments of the Helsinki Final Act. Today, I'm pleased to participate in this debate and to bring focus to the impact of armed conflict on the human trafficking of children. We know that at any given time, outside of times of conflict, there is an average of 25 million victims of human trafficking globally. Traffickers preying on marginalized and impoverished individuals and trapping them in sexual exploitation, domestic servitude, and forced labor. Exploiting people of all backgrounds, especially the vulnerable, or women, children, and undocumented migrants. For every 10 victims of human trafficking globally, 5 are adults, women, and 2 are girls. 1 in every 3 victims is a child. And in low-income countries, children account for about half of the victims detected. The risk of trafficking in conflict situations rises sharply when displaced persons have limited access to education, financial resources, and opportunities for income generations. They are unsafe and they are unprotected. Armed conflicts provides the environment for traffickers. And children are particularly at risk. Child trafficking during armed conflict is linked to grave violations of human rights. Russia's war of aggression in Ukraine has created new trafficking risks. The massive movement of refugees out of Ukraine has sharply increased the risk of victimization for human trafficking. The US State Department reports that within Ukraine, traffickers have targeted displaced persons and subjected some Ukrainians to forced labor in territories not under government control. Alarmingly, it cites reports of Russian-led forces in the Donbass forcing children to take part directly or indirectly in the war as soldiers, informants, and mail carriers. And we have heard the reports of children being separated from their families. Devastating and unacceptable, and immediate action is required. It is critical that we bring light to the serious crime of human trafficking, step up our efforts to combat it. I want to commend the members of the OSCE-PA for the strong call to action in fighting human trafficking in the Birmingham Declaration last summer. As parliamentarians, we have a role to play in raising public awareness of these crimes. We must work aggressively to end these crimes against children. Thank you for your attention.
Thank you. The next speaker is Mr. Robert Aderholt from the United States, followed by Mr. Tural Ganjaliev from Azerbaijan.
Thank you, Mr. Chairman, and it should go without saying because it has been the almost unanimous consensus of this room that we are absolutely horrified at the reports of the atrocities that have been committed by the Russian forces in Ukraine. That includes targeting of civilians, torture, attacks on residential buildings, schools, places of worship, and critical infrastructure, including nuclear power plants. The abduction of Ukrainian children to Russia for forced assimilation and adoption, sexual violence, destruction of cultural property, and imposed lack of access to food and water are just as worse, if not worse. Both reports from the 2 invocations from the Moscow mechanism last summer concluded that the Russian forces committed serious violations of international humanitarian law. While we rejoice in the liberation of each town and city from the Russian occupation, we are horrified at the testimonies of those who have lived under Russian control and the evidence of crimes left behind, especially torture, murder, and sexual violence. There's no justifications for these acts. They are barbaric, and because of the very fact of Russia attacked on Ukraine is illegal, every act committed by a Russian soldier, every shot fired, and every missile launched is therefore criminal. These actions must be looked at from the perspective of genocidal intent and dealt with accordingly. I'm also deeply concerned about the reports of rape and sexual assault committed by Russian troops against women, children, and men. This not only affects the effort to humiliate and to terrorize, but also amounts to genocide, as some women report of being told by their tormentors that they would be raped until they could no longer have Ukrainian children. On a side note, I would also like to say that we had a very good meeting in Washington earlier this month with several members of the Eastern European countries regarding the situation in Ukraine. I joined my colleague, Congressman Pete Sessions of Texas, and it was organized and helped organized by our fellow colleague from Albania, Fatmir Madu. And I'd like to thank Mr. Madu for his help in organizing that meeting in Washington, D.C. And with that, I yield back.
Thank you. The floor now goes to Mr. Tural Ganjalier from Azerbaijan, followed by Ms. Claudia Friedl from Switzerland.
Thank you, dear Chair. Please let me know, because I can't see the timer. When my time is up, please let me know. Öncelikle Türkiye'deki kardeşlerimize deprem nedeniyle hayatlarını yitirmiş insanlara göre Allah'tan rahmet diliyorum. Azerbaycanlı kardeşleriniz hemşe sizin yanınızda. Cher Monsieur le Président, chers collègues, l'Azerbaïdjan reste déterminé à poursuivre la réintégration des Arméniens dans les territoires azerbaïdjanais touchés par le conflit en tant que citoyens égaux sur la base de sa constitution et des documents internationaux pertinents qu'il a signés. Il s'agit exclusivement d'une affaire interne à l'Azerbaïdjan et sera traitée en conséquence. La réhabilitation et la reconstruction post-conflit dans les territoires libérés se poursuivent à plein régime sur la base des concepts de Smart City, Smart Village, appliquant les meilleurs standards internationaux. L'une de nos sérieuses préoccupations est la contamination massive par les mines continue d'être le principal obstacle à la réhabilitation et à la reconstruction post-conflit. L'Arménie n'a pas seulement manqué à ses obligations en vertu du droit international humanitaire de partager l'intégralité des registres des champs de mines. Au contraire, la pose de mines sur le territoire azerbaïdjanais s'est poursuivie même après la fin de toutes les activités militaires, conformément à la déclaration trilatérale du 10 novembre 2020. Un autre problème très sérieux est les conséquences tragiques de l'agression comprenant presque 4000 citoyens azerbaïdjanais portés disparus. Et parmi les civils, il y a des enfants, des femmes et des personnes âgées. Des citoyens azerbaïdjanais portés disparus en raison de la guerre entre l'Arménie et l'Azerbaïdjan en 1992 et 1994 doit être clarifié conformément au droit international humanitaire. Un problème urgent qui doit être adressé immédiatement est la protection des droits des Azerbaïdjanais expulsés de la République de l'Arménie. L'expulsion des Azerbaïdjanais de l'Arménie actuelle est une injustice sans précédent compte tenu de ses dimensions politiques, juridiques et humanitaires. Les résultats de ces actes restent sans réponse. Le patrimoine culturel et historique azerbaïdjanais, y compris les mosquées et les cimetières de l'actuelle Arménie, a été détruite, les toponymes ont été modifiés et une discrimination raciale systématique contre les Azerbaïdjanais a été pratiquée dans ce pays. Les personnes impliquées dans le nettoyage ethnique et d'autres crimes contre les Azerbaïdjanais et leurs méfiés sont glorifiés en Arménie en tant que politique de l'État. Le nettoyage ethnique contre les Azerbaïdjanais dans ce territoire a été mené avec les efforts systématiques des autorités de l'État en utilisant la violence, les massacres et d'autres crimes contre l'humanité. Merci.
Thank you. The floor now goes to Ms. Claudia Friedl from Switzerland, followed by Ms. Inka Hopsu from Finland.
Herr Vorsitzender, Kolleginnen und Kollegen, wir versammeln uns hier fast genau ein Jahr nach Beginn der militärischen Aggression Russlands gegen die Ukraine, als Ukrainerinnen und Ukrainer durch russische Raketeneinschläge auf ihre Städte und Dörfer aus dem Schlaf gerissen wurden. Seit 364 Tagen harren die Menschen in Bunkern, Metrostationen, in Ruinen, in kalten und dunklen Wohnungen aus. Ganze Städte sind zerstört worden. 18 Millionen Menschen sind auf der Flucht und fast 20.000 zivile Opfer sind zu beklagen. Die Aggression gegen die Ukraine geht Tag für Tag weiter. Ich verurteile diese Aggression und diesen eklatanten Verstoß gegen das Völkerrecht aufs Schärfste. Es liegen mehrere glaubwürdige Berichte vor. Direktor Matteo Megacci hat sie uns vorher aufgezählt.
Es liegen Berichte vor, die schwere Verstöße gegen das humanitäre Völkerrecht und die Menschenrechte belegen. Wir haben alle die schrecklichen Bilder aus Butscha gesehen, alarmierende Berichte von Folter und unmenschlicher Behandlung aus allen von den russischen Streitkräften besetzten Gebieten gehört. Kriegsverbrechen und Verbrechen gegen die Menschlichkeit müssen untersucht und die Täter zur Verantwortung gezogen und strafrechtlich verfolgt werden. Dazu müssen die Beweise für die Verbrechen erhoben werden. Die Schweiz unterstützt diese Bemühungen vollumfänglich. Abschließend fordere ich Russland dazu auf, umgehend alle Kampfhandlungen einzustellen und seine Truppen unverzüglich von ukrainischem Territorium zurückzuziehen. Russland hat diesen Krieg begonnen und Russland kann diesen Krieg wieder beenden.
Thank you. The next speaker is Ms. Inka Hopsu from Finland, followed by Mr. Vladimir Chizhov from Russia.
Mr. President, dear colleagues, we condemned Russia's brutal war against Ukraine a year ago, and we condemn it today. I deplore in the strongest term Russia's war crimes committed against children. Since the Russian attack on Ukraine, thousands of Ukrainian children have been abducted, some separated from the parents, deported, and forcibly adopted to Russian Federation. According to the Ukrainian government, 15,000 Ukrainian children have been forcibly deported to Russia. The real number might be as high as 121,000, according to the Ukrainian Commissioner for Human Rights. The Russification of Ukrainian children is a flagrant violation of human rights. Forced deportations from occupied territories are war crimes. They are used to change the demographic makeup of parts of Ukraine so that the Russian Federation is not only trying to destroy Ukrainian democracy, but also the Ukrainian identity and culture. Russia is not only stealing children from Ukraine, it is also depriving them of a future of freedom and democracy. The OSCE and the international community needs to use all its tools to stop the deportation of children and return them as soon as possible. Russia's attacks on civilians and civilian infrastructure have been severe. Current sabotage at the Kakhovka Dam could leave more than 1 million Ukrainians without drinking water. According to sources, lowering the dam's water level can lead to a decline of biodiversity and disrupt the operation of the Zaporizhzhia nuclear power plants, turbines, and safety systems. This war has brought nothing but suffering, and Russia has gained nothing good from it. This war needs to be stopped now, on Ukraine's terms, sooner the better.
Thank you. The next speaker is Mr. Vladimir Chizhov. Since he is the last speaker on my list, after his speech, I will ask our guest speakers to respond briefly to the debate. Mr. Chizhov, the floor is yours.
Благодарю вас. Конечно, военные действия неизбежно сопряжены со страданиями людей, с разрухой, с разрушениями и, увы, с потерей человеческих жизней. Жители Донбасса все это познали на себе еще с 2014 года. И действительно, дети Донбасса провели не 1 месяц, а некоторые не 1 год, сидя в подвалах, о чем говорили, имея в виду, очевидно, кого-то другого в этом зале. И сегодня продолжаются обстрелы, в том числе западными средствами огневого поражения, как артиллерией, так и ракетными установками. А Киев просит в том числе запрещенные виды оружия, включая кассетные бомбы, включая дроны камикадзе и так далее. И западные страны охотно идут навстречу. Да, я понимаю, что в такой ситуации точные цифры, статистики, сколько людей переместилось через одну или другую границу, довольно сложно. По нашим данным, с Украины в страны Евросоюза переехало в прошлом году около 7 миллионов человек, а в Россию около 5 миллионов. Так что это два совершенно разных потока тех, кого принято считать беженцами. А что касается дальнейшей судьбы тех, кто оказался в России, то статус тех регионов, где они разместились, он менялся. То есть эти люди сначала имели статус беженцев, потом они получили соответствующие российские документы, а сейчас они граждане новых субъектов Российской Федерации. Это касается и детей. Здесь разные цифры приводились. По нашим данным, они даже больше. По состоянию на ноябрь прошлого года в России оказалось более 700 тысяч детей. Не 17, а 700. Да, часть из них на сегодня остается в пунктах временного размещения, которые существуют в 61 регионе России. По состоянию на декабрь таких детей, я вам говорю совершенно точные цифры, 12 532 ребенка. Причем эти центры, они открыты для посещения. И, представители управления Высокого комиссара ООН по делам беженцев посещали. И представитель этого комиссариата в России подтвердил, что ему неизвестны случаи перемещения детей силой. И они также неизвестны тем партнерским неправительственным организациям, с которыми УВКБ сотрудничает.
Mr. Chicho, I'd like to ask you to limit your time, so 10 seconds, please.
Очень пафосных и претендуя на то, что по-английски называется high moral ground. В том числе представитель Великобритании, правительство которой, как известно, переселило, силой, можно сказать, часть мигрантов в Руанду. При всем уважении к этой африканской стране, наверное, это не идеал безопасной страны. В прошлом году был принят закон в Великобритании о национальностях и границах, который допускает силовое перемещение мигрантов.
You are 2 minutes over time, Mr. Chicho.
Границы между Соединенными Штатами Америки и Мексикой, я думаю, все и так хорошо знают. В Евросоюзе, я помню, как бывший глава Еврокомиссии, господин Юнкер, произносил крылатую фразу: Евросоюз строит мосты, а не стены. И что мы наблюдаем сегодня? Болгария строит забор на границе с Турцией, да еще пытается требовать за этот забор деньги с Евросоюзом. Польша в прошлом году фактически отгородилась от Белоруссии, оставив немалое число мигрантов практически в лесу, в тяжелых условиях. Теперь касается Международного уголовного суда. Здесь говорили, что вот Россия не участвует, что Украина не участвует. А то, как Соединенные Штаты Америки относятся к Международному уголовному суду, почему-то никто не сказал. Когда прокурор этого суда, госпожа Бенсуда, стала объектом откровенной травли со стороны американского правительства. И в заключение два слова буквально о московском механизме, о котором здесь говорили. Позиция Российской Федерации в отношении этого архаичного инструмента хорошо известно, изменений не потерпела. Московский механизм давно изжил себя и не отвечает современным реалиям. Он используется исключительно для оказания политического давления инициатором государства и руководства. Это подтвердило неоднократное конъюнктурное задействование механизма в последние годы, в том числе в отношении России. В этой связи
I again
по
ask you
доклада в
to
рамках механизма,
resist
включая
the
презентуемый
disorderly
сегодня,
behavior.
а также их выводы,
In the Rule 9, I direct that the fact I have called the member to order twice be recorded in the minutes of proceedings. Thank you. I would like now to ask our guest speakers if they would like to respond to the debate. Mr. Brishambo.
Merci, Monsieur le Président. Très rapidement, pour clarifier quelques éléments, je dirais premièrement que la Cour pénale internationale est pleinement compétente pour connaître des grands crimes, crimes de guerre, crimes contre l'humanité, génocide, commis éventuellement sur le territoire de l'Ukraine. Elle a été pour cela, comme je vous l'ai dit, saisie et par l'Ukraine et par 43 États. Le procureur est en train d'enquêter sur le terrain. C'est une tâche immense. Les nombres des crimes qui pourraient avoir été commis risquent d'être extrêmement élevés. Cela exige le concours d'équipes techniques, par exemple en matière de médico-légal, forensics, et cela exige la mise au point de bases de données, d'expertise qui permettront le moment venu d'identifier des affaires contre des individus précis pour lesquels il faudra créer des charges précises, des modes de responsabilité, et l'intention criminelle devra également être prouvée. Je précise que s'agissant de la Cour pénale internationale, elle n'admet pas l'immunité des chefs d'État. Et à cet égard, elle peut donc mettre en cause éventuellement, en raison de la responsabilité de commandement, les éléments les plus élevés des chaînes de commandement. Le procureur est à même de demander au juge d'émettre des mandats d'arrêt dans des délais très brefs. Il en a la possibilité. Je ne suis pas en mesure de dire s'il va le faire dans les semaines qui viennent, mais il est clair qu'il est déjà en train de travailler depuis de nombreux mois avec le soutien de beaucoup de pays présents dans cette salle. Quand il aura demandé au juge d'émettre des mandats d'arrêt, ceux-ci examineront le contenu de ces mandats et les approuveront le cas échéant. Il deviendra ensuite nécessaire d'arrêter les personnes en cause. Les procédures devant la Cour pénale internationale ne pourront commencer que quand les personnes recherchées seront présentes à La Haye. À ce moment-là, il y aura une première étape pour confirmer les charges, où un premier échelon de juge examinera par écrit les différents éléments probatoires qui lui sont soumis, ce qui ouvrira la voie à des procès. Ces procès seront accomplis, le cas échéant, avec toutes les garanties prévues par la pratique du droit international. Les accusés auront droit à des avocats, et il y aura des interrogatoires et des contre-interrogatoires des témoins. Et comme vous le savez, comme cela a été rappelé, la procédure devant les tribunaux pénaux internationaux peut être longue, mais elle implique la présence des victimes qui ont droit de s'exprimer et qui ont droit de participer au débat, ce qui est tout à fait important. La qualification définitive des crimes commis à l'égard par les accusés ne pourra être faite en cas d'appel que quand la chambre d'appel aura statué. Je sens bien que ceci peut être frustrant, que ceci exige du temps, mais c'est le prix à payer pour une vraie justice qui accomplisse pleinement sur le plan international comme sur le plan national toutes les garanties propres à un mécanisme impartial et indépendant qui ensuite a une grande autorité. Voilà à peu près ce que je voulais clarifier. Sur le terrain, bien entendu, il y a la nécessité d'une coordination entre les efforts menés par les juridictions nationales, la Cour pénale internationale et les autres juridictions qui s'intéressent à la situation. Cela implique des mécanismes ad hoc comme le Joint Investigation Team ou des mécanismes comme Eurojust. Là encore, on en est à une phase initiale des processus et il faudra une certaine patience avant que la masse critique puisse être atteinte dans un domaine très particulier. Ce domaine est celui des crimes de guerre, du droit humanitaire, et heureusement, il n'y a pas encore une grande pratique dans les tribunaux internationaux de ces crimes. Les juges devront donc se familiariser avec eux pour pouvoir prendre le moment venu des décisions et des jugements avec une parfaite information et une parfaite équité. Voilà, Monsieur le Président, j'espère avoir répondu aux questions qui ont été posées.
Thank you. Now I will give floor to Professor Bukova, please.
Yeah, thank you. I would like to briefly address the two questions which were asked by the representative of the United Kingdom, though I'm not sure whether he is still in the room. Yeah, you're here. The first one related to the precedent of Nuremberg and Tokyo, the frustration with this and whether we can expect better today. First, I don't think we should be so critical towards what happened after the Second World War. After all, it was the very first time when people responsible for crimes were not summarily executed, but prosecuted. And moreover, we should not only focus on Nuremberg and Tokyo, the two international trials, but also on the numerous trials which took place at the national level, and there were thousands and thousands of people prosecuted at the national level. So that's for the history. And can we expect even better today? Definitely we can, because we are much more willing, and we are also much better equipped today to proceed. We are much more willing, and that is visible in even what we've heard today in this room. The reaction to the Russian aggression against Ukraine and to the crimes committed in Ukraine is completely unprecedented. I don't remember a time, and my colleague would correct me if I'm wrong, when the war would start 1 week and the ICC would start investigating the next week. This is really an unprecedented situation, and the same is true for the national level. So we are definitely more willing. We are also much better equipped. We have the International Criminal Court we did not have decades ago. We also have legal rules in our national legal system which did not exist after the Second World War. And obviously, most of the countries in Europe and in other parts of the world are much better off than they were at the end of the Second World War. So we did not so bad after the Second World War, and it's quite probable that we will do much better now. And I would once again like to recall that we should not focus really only on holding perpetrators criminally responsible. It's important, but it's not everything. And now I'm not speaking only about victims, but there are also other tools of holding perpetrators somehow accountable. For instance, lustration or vetting procedures, and we should not forget about these. That's for the first question. The second question relates to top leaders, and it has already been partly addressed by my colleague with respect to the ICC. There are indeed obstacles to prosecute top leaders of the Russian Federation or potentially other countries, partly factual because it's difficult to get hold of these people, partly legal. The personal immunity issue, the reluctance to prosecute people in absentia, and some other legal obstacles. There are basically three strategies that can be embraced in this situation, and I leave the one strategy that you also proposed aside because I don't think it's a strategy to pursue. The first strategy is the wait and see and hope strategy. That means we will wait, we will hope that something will happen in the relevant country and that prosecution would become possible. The second strategy is do what we can strategy. That means that we will not probably at the moment start with the top leaders who enjoy the personal immunity and are not available, but not everyone is a top leader. Some people don't enjoy personal immunity and they can be held accountable at the national level. Some states do not necessarily, some states are not necessarily reluctant to conduct trials in absentia. And some of the top leaders or of leaders are actually available because they have been captured in Ukraine. So that's the second strategy. The third strategy is the change the rule or ignore the rule strategy. That's, well, the second one I leave aside, but the change the rules strategy is also possible. That means we will change the rules, for instance, on personal immunity or on trials in absentia. But here I would like to recall something that was said by the representative of Canada and that I highly appreciated, that if we change the rules for one state, or if we try to change the rules, we will not change them only for one state. We will change them for everyone. And if we ignore the rules today, then we might expect others to ignore the rule tomorrow. Obviously, it's never an excuse. You ignored the rule yesterday, and we can ignore them today. And I regret that the representatives of the Russian Federation have already left, because that was basically the only argument they were raising again and again. We are bad, but you are also not perfect. That's not a legal argument, but it obviously weakens the position if states proceed in this way. So that's it from my side. Thank you for your attention.
Thank you very much. Let me, on the behalf of the committee, thank our guest speakers for their valuable input. And I want to thank you, colleagues, also for an interesting debate. This has been a big topic, and the topic that we tried to address today, but one that I feel strongly must remain high on our agenda. The dangers associated with failures in this field are simply too great not to take them seriously. With this, I conclude. We close the agenda item 7, and we move to agenda item 8. But since there are no additional business, I hereby close this meeting. I thank you all for participation. I thank you all for keeping time. We are just 1 minute over our time limit. So thank you again, and I wish you best of luck in your endeavors, and have a nice evening. Thanks.